started. I welcome you all today. I'm very excited to be having our first virtual symposium, although I'm sorry that we're not having the symposium in person as we normally do. I'm just going to quickly go through the schedule. So I'm going to do a short introduction, and then I'm going to talk about residents' rights and protections against abuse and neglect in the regulatory and legal standards, just to give kind of a layout. And then Tom O'Hanlon, who is the Special Assistant Attorney General for the New York State Medicaid Fraud Control Unit, is going to provide some perspectives on investigating and prosecuting abuse and neglect. That'll be from about 10:05 to 10:50. We're going to leave 5-minute breaks in between each session so that people can take a break to use the bathroom or get something to drink, etc. And then, oh, thanks, Eric. I see I'm showing up at least on my screen. And then we're going to have a break for 5 minutes, and then at 10:55 approximately, Deborah Trahowski will of the law firm, excuse me, of DF Trahowski will be speaking from 10:55 to 11:40 on elder care, neglect, and abuse. And then I'm going to come back again after a 5-minute break from 11:45 to 12:10, talk about some resources for resident advocacy to hopefully build upon some of the things we've talked about and hopefully learned today. And then the last 45 minutes from 12:15 to 1 o'clock, we're going to have question and answers and a panel with the speakers who will be joined by the New York State Long-Term Care Ombudsman, Claudette Royal. So that's a brief overview of the day. Again, we're going to take 5-minute breaks in between each session. I thank you all very much for joining us today. Really appreciative of your being here. I want to give a special thank you to the New York State Health Foundation for supporting this program and for their wonderful support of this project, which has enabled us to provide focused outreach and support to nursing home families and to long-term care ombudsmen and others who work closely with residents and with their families. Also, a special thank you to Micaiah Salisbury, Janelle Tillman, and Avital Havusha at the foundation for their support of our work. I also wanted to express my appreciation to Claudette Royal, the New York State Ombudsman, and to everyone in the state office and the regional coordinators for supporting this work over the last 2 years and helping us to make this project so successful. I truly miss seeing you all in person today. We normally have this program it was scheduled to be in June, and we had one the previous year in New York City, and we bring in people from across the state. And it's gorgeous here in New York, so I'm sorry that you couldn't come and visit. And we have a really nice program. It's always great to see everyone, but I'm looking forward to an interesting and informative program today. I thought before we get started, I would just provide you some background on the two other speakers besides myself, and then we can get started and therefore just flow through the program more smoothly in between the breaks and everything else. So Tom O'Hanlon is the Chief of Criminal Investigations downstate in the New York State Attorney General's Medicaid Fraud Control Unit, what we refer to as the MFUCU, Medicaid Fraud Control Unit. The MFUCU investigates and prosecutes financial crimes in the state's Medicaid program and the abuse, neglect, and mistreatment of residents of residential care facilities, including nursing homes. As Chief of Criminal Investigations downstate, Tom supports the development of MFUCU's major investigations statewide and supervises the MFUCU New York City, Long Island, and Westchester Rockland regions. He's the co-chair of the National Association of Medicaid Fraud Control Units Association Resident Abuse Committee. Tom has lectured in New York and nationally on investigating, prosecuting, and most importantly, preventing Medicaid fraud and nursing home resident abuse and neglect. And I'm really thrilled that Tom's with us today. Deborah Trahowski is an elder neglect attorney and a staunch and committed advocate for the elderly. She lectures frequently on matters relating to elder neglect and abuse and has provided numerous trainings for us at the Coalition and for LTC Ombudsman. She's among the most powerful, thoughtful, and passionate advocates for nursing home residents that I know personally, and I am very proud that she's the president of LTCCC's board of directors. She's truly been a phenomenal and visionary leader of our board. Again, I'm going to start the program with a brief discussion of the foundations of nursing home requirements and then provide some specific information on protections against abuse and neglect. Those of you who have attended our programs before know that I tend to provide a lot of information when I speak. My goal is to give you all a sense of how strong the standards of resident care and dignity are. However, there's no need to take notes or try to remember details. We have resources on our website, which I'll discuss later on, which you can use to support your resident-centered advocacy. Again, my goal is really to make sure that we are providing, that we're plugging in with you on what is most important and what is needed about resident care. So I'm going to share my screen. Just 1 second. There we go. Hopefully this will be, and yes, it looks like you can all see this. There we go. So again, I'm going to talk a little bit about how the nursing home system works and then really focus on some of the requirements for ensuring that residents are protected from abuse, crime, and neglect. It's really, it's such a breathtaking issue every single day, and even more so during the COVID-19 pandemic, that we had planned the topic for this well before COVID-19, but certainly COVID-19 has made clear how much more, how necessary this discussion is and how necessary our advocacy here is. So a little bit about nursing homes, and just to give you a background, because I think this is, this is really important. Um, as I note here, virtually all nursing homes participate in Medicaid and/or Medicare. And by participate, that's a government terminology, meaning that they take money either from Medicaid and/or Medicare. The vast majority of nursing homes participate in both Medicaid and Medicare. And the reason why that's important is that in order to do so, a facility agrees to meet all the standards provided for in the federal nursing home reform law. Now, states can have additional protections, but no state can have less protection. So you'll hear spoken about today, federal rules as well as some state rules. The state rules all really are replicated in the federal rules, and that's true across the country because every state has to essentially have adopted the federal rules. Every state is required to enforce the federal rules, and states can have additional rules. For instance, most states now have a minimum staffing standard, meaning they have a minimum number of RNs, LPNs, and CNAs per resident per day. Our home state, New York, is one of the minority of states that has yet to pass a minimum staffing standard. Our neighbors in New Jersey just passed one, and it was signed into law within the past couple of weeks, which is really exciting. And I hope that we'll see further movement on both the federal level as well as on the state level to ensure that there is proper staffing. Importantly, the federal protections that we talk about and all the state protections as well, they are for every single resident in the facility, no matter who pays for their care. It is not appropriate, it is not legal for a facility to say, oh, your resident is on Medicaid and we do not get enough money to provide X level of care for him or her. That is just wrong. Again, the protections, the quality of care, the services go to every single resident in licensed facilities, no matter who pays for their care. The federal agency is the Centers for Medicare and Medicaid Services, and they contract with the State Department of Health to ensure that residents are protected and receive the services that they need and that they deserve and for which we pay every single day of the year. That's really the role of CMS, Centers for Medicare and Medicaid Services, and the State Department of Health to ensure that is happening 7 days a week, 52 weeks out of the year. So I just wanted to talk a little bit about the nursing home reform law. So the federal law requires that every single nursing home resident, I know I'm going to keep on saying that, every single resident, no matter who pays for his care or her care, is provided the quality of care and the quality of life services sufficient to attain and maintain his or her highest practicable physical emotional, and social well-being. And it's highest practicable, not highest practical, meaning that practicable means what I am capable of doing, or what level of functioning I'm capable of achieving with appropriate services. It does not mean highest practical, meaning that a facility wishes to put, say they get $200 a day to care for a resident, that they want to put $40 of that into profits, and that leaves them $160. And so what's practical for them to provide after cutting out $40 in profits? That's not what we're talking about here. We're talking about highest practicable based upon the individual resident. And the law, as I note here over and over again, emphasizes that care services must be directed towards the individual and what he or she needs to achieve his or her highest practicable physical, emotional, and social well-being, all of those things. Importantly, the law lays out specific resident rights, from good care and monitoring of the resident, from pressure ulcer monitoring to fall monitoring, et cetera, to quality of life that maximizes resident choice, dignity, and autonomy. Many of you hopefully know that we do monthly webinars that provide information and tools on how to achieve this, and I welcome you to join us for those. Now, the Nursing Home Reform Law passed in 1987. The regulatory standards came out almost 30 years ago in 1991. They were revised a bit about 4 years ago in 2016. And the reason why I mention that is because none of this is new. The rules, again, have been in place for close to 30 years. The revisions in 2016 made some pretty minor tweaks for the most part, but the basic residence rights, the basic regulatory standards have not changed since they were first implemented in 1991. None of this should be new to any provider of care that you encounter. So I'm going to talk a bit about some of the specific issues related to abuse, neglect, and crimes against residents, which I also wanted to include here. Why are we talking about this? Of course, because too many residents are abused, too many residents are neglected. Oftentimes, over and over again, we see repeat patterns of issues in nursing homes, repeat patterns of neglect and abuse against residents, and a lot of that has been exacerbated during COVID-19. It's important to keep in mind that even though some of the rules for nursing homes, in terms of reporting, in terms of some other more administrative activities have been weakened, or have been relaxed, I should say, during the COVID-19 pandemic, residents' rights have all stayed the same. And residents have the right to both good care, appropriate food services, appropriate care services, appropriate recreational services during the pandemic. So I'm going to start out just with some basic language, and actually the next few slides before I finish up will really focus on some of the language either directly from the federal rules or from what's called the interpretive guidance, how the federal rules are interpreted. It's called sub-regulatory guidance. And essentially, it's not the rule itself, it's what we expect facilities to be doing in order to make sure that the rule, that they are in compliance with the rule. As you can see here on the left-hand side, I include under the federal requirement, the Code of Federal Regulations number 42 CFR 483.12, as well as the FTAG number. This is F600. These are not things, again, as I said at the start, we provide a lot of details and a lot of information. There's no reason to memorize. There's no reason to take notes. We have all these materials are available in brief handouts and fact sheets, et cetera, on our website. Everything is free, of course. The reason why we include this here, and the reason why you'll see this in a lot of our materials, is because I want you to be able to take this in your advocacy, not just say, oh, Richard Mollett, said this at a program, or when we used to be able to meet in person, and I would do in-service trainings, et cetera, that this is something that I said. This is actually in the federal rules, and you can see everything that's italicized, including what's italicized here on the right-hand side, comes either from the federal rule itself or from the regulation. So we want you to be able to have the grounding to advocate that it's not just something that I said, it's not just wishful thinking, that it is actually what is in the rules. And then secondly, and lastly, the FTAG is this is what is used by surveyors, the nursing home inspectors, for both state surveyors and CMS surveyors. When they go into a nursing home, if they find a violation, they cite it with an FTAG. So every single rule, every single regulation that relates to nursing homes has an associated FTAG. This is just important. Again, I just wanted to plug in with you here, but this is important because if you're in a facility and you see that facility, if you look at their deficiency statement and you see, oh, they were cited for F600, you can go back, you can look that up, you can see what the citation involved, what the rule was that they failed to achieve, and then look to see if you're advocating in that facility for yourself, for a loved one, for your residents as an ombudsman or an advocate. You can see, okay, what has the facility done to correct this? Because that is what is what is required to happen, even though too often, I should say, it doesn't happen. So again, these are all really tools, that are in your arsenal, so to speak, to advocate, to make sure that nursing homes are held accountable for improving, for addressing issues, et cetera. So I want to talk a bit about the freedom from abuse, neglect, and exploitation. These are, again, this is from the federal guidance, key elements of non-compliance for abuse and neglect. So this is what the government is saying we should be expecting, or what we should be looking for in terms of what does non-compliance mean. It means that the facility failed to protect a resident's right to be free from any type of abuse, including corporal punishment, and neglect that results in or has the likelihood to result in physical harm, pain, or mental anguish. Or the facility failed to ensure that a resident was free from neglect when it failed to provide the required structures and processes in order to meet the needs of one or more residents. So really think about that, especially the second paragraph, is that the facility has responsibility here. We recognize, at least on paper, that the facility really controls everything in the nursing home, and therefore it is the facility's responsibility. The buck is supposed to stop with them. I wanted to include some important definitions here. And again, we have this in materials on our website, a lot of one-pagers, so they're very easy to use. Too often we hear from providers like, oh, we're not sure what that means. What does abuse mean? What does neglect mean? What does sexual abuse mean? What does willful mean? We'll talk about this a lot in my next few minutes. Abuse means the willful infliction of injury, unreasonable confinement, intimidation, or punishment with resulting physical harm, pain, or mental anguish. Abuse also includes the deprivation by an individual, including a caretaker, of goods or services necessary to attain or maintain physical, mental, and psychosocial well-being. And again, I just want to quickly point out as an aside, see, you hear that language, attaining, and maintaining physical, mental, and psychosocial well-being. This we see throughout the rules. We're talking about abuse and neglect today, but we see that in terms of other resident services as well, that over and over and over again, the rules are really strong and they're really good and they're really resident centered. The issue from our perspective is that because they're not well enforced, nursing homes too often, they ignore them. But here you see over and over again, we expect to see that the services provided to the individual are sufficient to help them attain and maintain physical, mental, and psychosocial well-being. So this is really important. I put it in bold. Instances of abuse of all residents, irrespective of any mental or physical condition, cause physical harm, pain, or mental anguish. Not may cause physical harm, pain, or mental anguish. It includes verbal abuse, sexual abuse, physical abuse, and mental abuse, including abuse facilitated or enabled through the use of technology. One thing that they're talking about here very specifically is we've heard over the past couple of years, and a lot of this we actually learned from the Medicaid Fraud Control Unit, was of care staff that were filming residents in humiliating situations and then sharing it on Snapchat. And that's something that we're very happy to have seen that our Medicaid Fraud Control Unit, as well as others, have worked to address, because it's really terrible. Importantly, just to inform you all, if a resident has dementia, then essentially that doesn't. It's really important to know, excuse me, that that doesn't mean that it's okay to do something embarrassing to them because they don't realize that they'd be embarrassed. CMS, over and over in the rules and the sub-regulatory guidance, says that a resident with dementia has the same rights as someone who doesn't have dementia, and that would be what a reasonable person, no matter what his or her cognitive status, but a reasonable person would consider to be embarrassing, would consider to be abusive, would consider to be neglectful, etc. There is absolutely zero, no excuse for treating residents with dementia any other way, including in respect to their dignity and their emotional and psychosocial well-being and treatment. Neglect is the failure of the facility, its employees, or service providers to provide goods and services to a resident that are necessary to avoid physical harm, pain, mental anguish, or emotional distress. Sexual abuse is any non-consensual sexual contact of any type with a resident. And then lastly, willful, and again, I'll talk about this a little bit more. Willful means the individual must have acted deliberately, not that the individual must have intended to inflict injury or harm. It's a really important distinction. Again, we'll talk about that a little bit more. So freedom from abuse, neglect, and exploitation. Here are some excerpts, again, from the federal guidance. What is the facility responsible for? The facility must provide a safe resident environment and protect residents from abuse. Again, the buck stops with the facility. This I thought was really interesting, and this is why I included it here, is I wanted to show what the federal government is saying that state surveyors should look for in respect to what are the characteristics of a nursing home that are associated with increased risk of abuse. And I thought that was really important for us. It's a little bit harder now, of course, since we're not yet, for the most part, going into facilities, although I think that it is hopefully changing soon and maybe incrementally, but that we are seeing some changes there. But these are some of the characteristics. And I think even if you're talking to someone over the phone, even if you're visiting remotely, you can also use some of this as kind of clues, as these are some of the characteristics, not my ideas. These are, again, from the federal guidance of what is associated with increased risk of abuse. Unsympathetic or negative attitude from staff toward residents, chronic staffing problems. CMS is recognizing that staffing is an issue. Lack of administrative oversight, staff who are burnt out, stressful working conditions, poorly trained staff, people who are not equipped with the information and the skills that they need to carry out the care that they've been charged with providing for residents, deficiencies in the physical environment of the nursing home, and facility policies that operate in the interests of the institution rather than the interests of residents. And I know, I've spoken to many of you, especially over the past couple of years, that these are things that we have seen and things that we're concerned about. Again, these are things that the federal government itself has recognized as characteristics that are red flags, that there's a high likelihood or increased risk of abuse, and what the state surveyors should be looking for, as well as, of course, us. So I'm going to talk about some of the specific resident abuse, resident abuse. Pardon me. I just want checking to see how my time is doing, and I think I'm doing okay. So here's staff to resident abuse of any type. And again, we'll post this, but we have a lot of materials on the website that are very specific to help you if you are faced with one of these issues. CMS again notes, and you can see everything here in italics comes directly from the federal guidance. I put it in bold for you, but all this is really from the federal guidance. CMS recognizes that nursing homes have diverse populations, including residents with dementia, mental disorders, intellectual disabilities, ethnic, cultural differences, speech, language challenges, and generational differences. When a nursing home accepts a resident for admission, the facility assumes the responsibility of ensuring the safety and well-being of the resident. I'm going to say it one more time. When a nursing home accepts a resident for admission and retains that resident, I'll add that, the facility assumes the responsibility of ensuring the safety and well-being of the resident. It's the facility's responsibility to ensure that all staff are trained and knowledgeable in how to act and how to respond towards resident and residents' behavior. A facility cannot disown the acts of staff. They cannot say, oh, that was someone who they were acting in a way we couldn't control them. The facility takes responsibility. Again, the buck stops with the facility. And then lastly, I just wanted to mention, which again is from the rules, CMS does not consider striking a combative resident an appropriate response in any situation. It is also not acceptable for an employee to claim his or her action was reflexive or a knee-jerk reaction and was not intended to cause harm. Retaliation by staff is abuse, regardless of whether harm was intended, and must be cited. Again, these are what the CMS is telling the state, must be cited. Completely unacceptable. Resident-to-resident abuse of any type. Also, again, the CMS is saying that we are expecting the nursing home to be properly monitoring and evaluating on a constant level. So here, resident-to-resident altercation should be reviewed by the surveyor as a potential situation of abuse. Having a mental disorder or cognitive impairment does not automatically preclude a resident from engaging in deliberate or non-accidental actions. And here again, the guidance talks about what is willful versus what is not willful. An example of a willful action would be a cognitively impaired resident who hits a resident within his or her reach, as opposed to a resident with a neurological disease, someone who has involuntary spasms, twitching, jerking, and his or her body movements impact a resident who is nearby. Very, very different. So again, willful doesn't mean, oh, I intended to hurt you. Willful means that the person acted, and it's up to the facility to be ensuring that they are constantly monitoring and constantly reevaluating to assure the safety of residents. And this is again, you see the language here that the facility has a responsibility to be doing that monitoring and to be adjusting things accordingly. I wanted to quickly talk about cracking down on crimes against nursing home residents. This is a huge issue, again, because abuse and neglect are such serious problems and such painful problems, of course, for the residents, for family members, for ombudsmen and advocates. Anyone who is concerned about elder abuse, we know that it's on the rise in the country. It's become increasingly recognized as a problem. And in nursing homes, where again, the nursing home really controls everything, it's something about which we are particularly concerned. So to address the longstanding issues of ongoing abuse and neglect in nursing homes, in 2010, the Affordable Care Act, so-called Obamacare, actually included several provisions of the Elder Justice Act, one of which required, that reporting of crimes against resident, any suspicion of a crime against resident. And this goes to everyone who works in a nursing home, whether it be the care staff, the owners and the operators, or contract workers that have come in. The nursing home has a responsibility to inform them all of their duty to report immediately when there is a suspicion of a crime that resulted in a physical injury to a resident. It must be reported within 2 hours. So reporting, again, sorry, I don't think I was clear there. Reporting has to be done right away, but it's a violation if it takes place, if the reporting takes place more than 2 hours later and the crime resulted in physical injury to a resident. Otherwise, they have 24 hours within which to report. But really, it's the point is it's supposed to happen as soon as possible. And if you didn't do it within 2 hours and it results in a physical injury, then you're going to potentially be penalized even more. Reporting has to be done to both local law enforcement, which could be the Medicaid Fraud Control Unit, by the way, and to the state agency, the Department of Health. And failure to report covered carries a penalty of up to close to $250,000. And if the failure exacerbates resident harm or leads to harm of another resident, that fine can be up to about $340,000. So we have just a small chart here, which we have on our website as well, which distinguishes between what the reporting of crime is and what the reporting of abuse and neglect is for residents and for the facility. And then lastly, here is our fact sheet. Again, as I mentioned, no need to memorize really anything. I just wanted to plug in with you and see how deeply the protections are against resident abuse and neglect. And I think I am actually pretty good on my time. So we are going to, there we go. Thank you, Eric. So we're going to take about a 5-minute break. We're going to start again at 10:05. So it'll be a 4-minute break, and we'll see you in a few minutes. Just while we're taking our break, just to let you know that if you have any questions, please put them in the question field at the bottom, the Q&A at the bottom of your Zoom screen, and we will get to them during the panel, or we'll try to get to them during the panel. And you can use the chat, of course, if you want to make any comments amongst yourselves, etc. So nice to see some familiar names on the participant list. Welcome everybody again, and thank you. We'll be back in about 4 minutes. Hi, everyone, and welcome back. I'm now going to hand this off to Tom O'Hanlon. I'm very excited to see his presentation as well. So welcome, Tom, and thank you for joining us.
Thanks. Just have a moment. All right, I'm trying to get my PowerPoint up. Okay. Richard, can you see that?
Yes, I can. Thanks.
Terrific. Well, thanks very much. Thank you, Richard. As Richard has said, my name is Tom O'Hanlon. I'm an Assistant Attorney General with the New York State Attorney General's Office. I'm the Chief of Criminal Investigations downstate for the Medicaid Fraud Control Unit in the Office of Letitia James. Now, I'm a trained trial lawyer, so I'm used to moving around quite a bit when I present, and I'm still not used to staring at the small dot on the screen, but bear with me. We really appreciate our great working relationship with the LTCCC. We have quarterly meetings with Richard and the associate groups and representatives that I've got to know quite well over now the last 8 years. And it's really a great opportunity for us to exchange ideas, to learn from one another. I know I learned quite a bit, so I really value the relationship and those meetings. So I'm happy to be here. I'm honored to participate in this long-awaited fall symposium on identifying and addressing abuse and neglect in nursing homes. These obviously have been extraordinary times for all of us, but they have been particularly tragic for our most vulnerable, those residents of nursing homes across the state. The New York State Medicaid Fraud Control Unit has continued since March 16th, that day that we all remember well, the last day that I was in our New York City office. But we have maintained our operations. We have been incredibly active in terms of doing our investigations. I am working with the nursing home sector, supporting them when appropriate and holding them accountable when appropriate. Given the pandemic, our resources have shifted almost exclusively to the nursing home sector, and I'll talk a little bit about that. But before we begin, a little housekeeping. I am a lawyer, so I think every lawyer presentation for the most part, especially for those of us in government, start off with this. The views and opinions, my views and opinions are entirely my own, and of course do not express the views or the official policy of the New York State Attorney General's Office. Of course, I cannot, and I apologize for this, but I think most of you understand, I cannot comment on the existence of any ongoing investigations. But we're going to talk a lot about what MFUCU is, what we do. I've met many of you, but some of you, obviously, I have not. So I want to talk to you a little bit about what the Medicaid Fraud Control Unit does, our dual mission to investigate and prosecute resident abuse and neglect, and also to conduct investigations into provider fraud. We'll talk a little bit about that. I'm going to springboard off of a lot of what Richard spoke about in terms of the legal foundations behind our investigations. Richard talked a lot about those fundamental federal regulations that protect residents in nursing homes and hold nursing home operators accountable. So I'm going to talk a little bit about the New York regulations that all deal with the same issues, but focus on different aspects of that. I'm also going to talk to you about the outreach that the Medicaid Fraud Control Unit does. We're not just a prosecutor's office. Our focus is really preventing resident abuse and neglect rather than prosecuting someone for it. So we do a lot of outreach. We go out to the facilities and we sit down with the caregivers in those facilities, and we talk to them about issues involving resident abuse and neglect. I'm going to touch on some of that. And then we're going to talk about what the Medicaid Fraud Control Unit has been doing during the pandemic. So we investigate and, if warranted, prosecute Medicaid provider fraud and abuse and neglect in residential healthcare facilities. Now, that goes beyond just nursing homes, as many of you know. I saw that there was a question about facilities that treat individuals with traumatic brain injury, and we do cover those facilities as well. And we've had a number of major investigations and prosecutions that have come out of traumatic brain injury facilities in very sad cases. And how do we do it? We achieve justice through criminal prosecution, civil actions. We have a very robust civil enforcement division that is just another tool that we use to hold nursing home operators accountable and ensure the safety and protection of nursing home residents throughout the state. And of course, we protect Medicaid program integrity. The Medicaid program, while now is up to over $75 billion program in New York, there are limited resources, and we want to ensure that those resources are available to our state's most vulnerable, and that those folks that need that care are receiving it. And when they receive it, that they're being treated with respect and dignity. So just to recap, our jurisdiction is financial fraud and resident protection. So who are the folks that make up MFUCU? Well, they're attorneys like me. We have experience investigating and prosecuting resident abuse. Right now, there are about 60 attorneys statewide. We also have our staff of auditors, which really sets us apart from a lot of other prosecutors' offices, in that we have a in-house group of auditors that assist us with a lot of things. But in terms of our major nursing home investigations, they play a critical role. I'll get into that later. Obviously, it's 2020, and a lot of our investigations involve data. So we have a really terrific electronic investigative support group. Within that, we have data scientists who help the teams, the investigative teams, identify trends and spot trends that could be relevant to various issues, underperformance issues in a nursing home that we may want to address. They are terrific. Our electronic investigative support group, I mentioned, we all went out on March 16th. We were all up and running at home on March 17th, doing investigations, communicating amongst ourselves, having statewide meetings, obviously communicating about developments in the pandemic. It was a scary time for everyone. It was a particularly scary time for us because we were concerned. We knew that the nursing home sector was going to be vulnerable. We were concerned about our ability as really one of the only state agencies that holds nursing homes accountable and ensures the protection of nursing home residents. We're going to be able to do our job. And I'm happy to report that we have been incredibly successful. And I think we've exceeded everyone's expectations about how effective we have still been able to be, even though we haven't gone into the office. So obviously our investigators are critical to our investigations. All MFUCU investigators are police officers. They're trained in abuse and neglect investigations. Many of them come from a special victims background, and they do a wonderful job getting out into the facilities, meeting with victims, meeting with witnesses. And then, of course, our ace in the hole is our nurse investigators. We have a number of nurses statewide that assist us in our investigations. These nurses have varied experience. Many of them have worked in nursing homes, and they assist the attorneys and the investigators with the policies and standards of care in nursing homes. And they also assist us in reviewing medical records and really helping us navigate through what often can be incredibly complex situations. So where are our offices? Well, our main office is in New York City that some of you have been to. We were at 120 Broadway for many years. A few years back, we relocated to 28 Liberty Street, and we're there on the 13th floor. We haven't been there in person since March 16th, but we're slowly moving back. Our other offices statewide, from Buffalo out to Hop in the west to Hauppauge in the east, we're back on a limited basis in those offices. But in terms of your ability to contact us, nothing has really changed. We are easily accessible. I'm proud to say that we're one of the, I'm proud to say that if you call the Medicaid Fraud Control Unit or you shoot us an email, you're going to hear back from someone. I know that that always isn't the same with a lot of government agencies, but we recognize the importance of having to move quickly on our investigations. This symposium is entitled Identifying and Addressing Nursing Home Resident Abuse and Neglect. And the identifying is often the key. That's often the challenge, as many of you know. So we are accessible. We do have a physical presence across the state, and here are those offices. So in terms of the work that we do, the results, the Medicaid Fraud Control Unit traditionally brings in more money than our operating budget. Last year, we had 71 criminal convictions, but that's not all we do. The criminal prosecution side of the house is obviously a very, very important aspect of the work that we do, but we do more than that. Just our physical presence in terms of public awareness, deterrent impact of what we do, and then of course, the civil work that we do as well. Last year, we had $168 million in ordered recoveries, and we're fortunate that we have a very, very high overall conviction rate, and that has always been the case, and that's the result of really a very high degree of professionalism within the office and a lot of hard work. Folks in my office are incredibly passionate about our work because of the real human impact that it has. And it shows in the results. So Richard talked a lot about, and it was very instructive, and thank you, Richard, for that, because I always like reviewing that material. But if we're going to talk about Mafuku's investigations, we do have to talk about the underlying regulations that really form the legal foundation of our work. And when I talk to people about the regulatory and legal protections that nursing home residents have in New York, I like to start at the beginning. And when you look at the New York regulatory scheme, this is some of the first language. And the regulations are based on the concept that for a nursing home resident, for a resident of a healthcare facility, it's often their last home, and it should be treated as their home. And the caregivers that provide care and the operators of these facilities need to keep that in mind. And we hold them accountable to that fact that these folks should be treated as if this is their home. And sadly, but it is the reality, it's often their last home. And the second quote that I include in this slide is that a license to operate a nursing home carries with it a special obligation to residents who depend upon the facility to meet every basic human need. A special obligation. That's terminology that we don't see in the law too much, but it's absolutely appropriate to nursing homes because of the human impact that these businesses, and they are businesses, have on the most vulnerable among us. So it's something that we keep in mind. It's something that we remind the nursing home sector of. And it obviously plays an important role in all the work that we do, whether that be a criminal prosecution or a civil enforcement action. Again, talking about accountability. Now, this is a Medicaid regulation, but no payment will be made for medical care furnished in violation of any condition of participation in the program. So all these regulations that we're talking about, both federal and state, are conditions precedent for payment. So in terms of holding a facility accountable, this is obviously a key provision of the law that allows us to recoup money and to take back money when the services that are being provided are grossly substandard, or as defined in the law as worthless services. So if you have an instance of grossly substandard care, neglect, abuse, mistreatment, what the Medicaid Fraud Control Unit will do, and we'll get into this a little more about the mechanisms that we use, but we look to recoup that money. So Richard talked about the quality of life regulations, citing to the Code of Federal Regulations. So I don't need to rehash them, but the language speaks for itself. To maintain the highest practicable well-being, the nursing home provide a safe, clean, comfortable, and home-like environment. The home is really the foundation of so much of the work that we do, and we look to hold operators accountable. The right to respect and dignified existence, also critical. So 10 NYCRR 41526 is an incredibly important regulation in the New York nursing home regulatory scheme, and it's gotten a lot of attention during COVID-19 because nursing homes have been required to admit residents during COVID-19, even if they were positive or presumed positive of COVID. But this regulation 41526, that the nursing home shall accept and retain only those nursing home residents for whom it can provide adequate care, that regulation was never waived. So again, another important safety net for residents, that nursing homes are legally prohibited from admitting a resident if they cannot provide adequate care. And that's something that obviously has been very relevant during the pandemic. So when we're talking about the abuse and neglect laws and regulations, I thought what I could do is talk a little bit about how, when covering them, talk a little bit about how we convey, the Medicaid Fraud Control Unit conveys these regulations and laws to caregivers when we go out into the facilities across the state. We've always done that, but a couple of years ago, we really upped our game in terms of making an effort to get out to the facilities to teach the direct caregivers about the laws that protect nursing home residents, the laws that protect those caregivers within a facility, and to really encourage them to report instances of neglect and abuse when they see it. Now, they're obligated to do so under the law. We're going to get into that. But having that direct contact with them has proven to be very, very successful. One of the themes of these caregiver outreach presentations is preventing neglect and abuse rather than prosecuting someone for it. We're far more interested in preventing neglect and abuse before it happens than prosecuting somebody for neglect or abuse. So these are some of the messages that we convey to them, reminding them really of the dynamic that it's the resident's home that they're in. While it is their place of work, and they certainly have rights, that they're in the resident's home. We talk about the respect that we have for them, and we want them to know that because it's true. We have an incredible amount of respect that caregivers in residential care facilities have, that we have for them. We appreciate the patience, dedication, and tolerance that they have doing an incredibly difficult job. We remind them that we don't prosecute individuals for honest mistakes that happen in nursing homes. We want them to know that the laws are designed to protect the sick, the disabled, the elderly from those who knowingly violate the law. Richard talked about willfulness, which is an important state of mind element in a lot of the crimes that we prosecute. It in New York is interpreted as knowing, that an individual will violate the law if they knowingly do something to neglect or abuse or mistreat a resident, or if they take an unjustifiable risk and hurt or, God forbid, kill a resident. And I'm sure many of you know that the Medicaid Fraud Control Unit routinely is looking to hold facilities and individuals accountable for recklessly causing the death of nursing home residents. So resident abuse, and this is actually a slide. Some of you may have noticed that we went from a gray background to a blue background. It's because I wanted to share with you some of the actual slides that we use in our presentation. And this is the definition of abuse in New York. Any person who commits a willful act of physical abuse, neglect, mistreatment, or who fails to report such an act is subject to 1 year in jail and or a $10,000 fine. And that's a provision from the public health law. Here's the definition of abuse: doing something which harms or is likely to harm a resident, striking, pinching, kicking, shoving, sexual molestation. One of the things that we do share with the caregivers is that sexual abuse does occur in facilities. We talk about some of the identifying factors that could be involved that they need to be on the lookout for. Neglect, the definition of neglect under the state regulations is slightly different than the federal regulations. It's a failure to provide timely, consistent, safe, adequate, and appropriate services. And it's really a catch-all for just the basic poor substandard care that we see. This definition of neglect is a very common theme in our criminal prosecutions and or civil actions. We talk to them about understaffing, systemic understaffing. It's something that is incredibly important to the work that we do. We are always trying to identify those facilities that put profits over people and that fail to have adequate staffing to provide, as Richard said, the highest practical mental and psychosocial well-being of each resident. Failure to have appropriate staffing almost results in per se neglect. I'm sure Richard would strike almost. And it also is unfair as we communicate to the caregiver community. It's unfair to them that they're being put in a position where they're set up to fail. And most importantly, the residents suffer and they're not able to get the care that they deserve under the law, that they deserve as human beings. So we remind them of these laws. Many of them are not aware of the laws that apply to nursing homes, the laws and the obligations that apply to nursing home operators. And when we go over this material with them, you often see light bulbs going off. It's really had a very positive effect because, again, identifying, especially now, we are relying on nursing home employees to bring to our attention instances of neglect and abuse inside nursing homes because we've lost one of the most critical referral sources, and that is, of course, the families. And it's as Richard touched on, it's just a very tragic aspect of many tragic aspects of the pandemic. I just want to check my time. Okay. So we encourage them to report understaffing, which they're required to do under New York's mandatory reporting statute. And we try to explain to them that understaffing not only affects the residents, but it affects them and really exposes them to even potential criminal prosecution, and that they're entitled to appropriate support. We remind them that, of course, even under the worst of circumstances, that they're required to do their job, but they're required to report the incident to, they can report to their supervisor, their union representative, to the Department of Health, and of course to the Attorney General. So this was the mandatory reporting statute. I'm going to go through some of these slides more quickly because I do have limited time. I want to stick to the agenda. But mandatory reporting, the failure to report, is a misdemeanor. So in terms of level of criminality, it's actually the same level of a criminal act as the underlying abuse. And mandatory reporting is so important to ensuring the safety and welfare of nursing home residents. And they must report upon reasonable cause. And it's an individual duty. What we often hear in facilities is, oh, I told my supervisor, oh, I told my the administrator, I told the nurse. It's an individual duty. Obviously, if we can confirm that they did in fact tell someone, it's important, but it is, the legal obligation is for each individual to immediately contact the Department of Health if they have reasonable cause to believe that a resident of the facility was neglected, abused, or mistreated. So who do we tell them they can call? The Department of Health. And of course, they can call us. Richard mentioned the Elder Justice Act, which is basically the federal mandatory reporting statute. But the difference between the Elder Justice Act that was passed as part of the Affordable Care Act is that there's no criminal sanction associated with failure to report. In New York, it's a crime punishable by up to a year in jail. Now, it's only in the most egregious cases where someone would look at jail time potentially, but that has happened. So there are whistleblower protections, and many of you that are in facilities, should be aware of this. And these are communications that we should be having staff, because these folks don't make a lot of money. They're raising families, and they're terrified, and we're aware of this when we do our investigations. They're terrified of the individual repercussions that they can have on their livelihoods. And we try to stress to them that there are protections, and that facilities could be subject to really massive fines for retaliation against a well-meaning employee that's complying with the law and being a decent person. And not only does it involve fines, but it also could impact the underlying case. So our tools, just to quickly review, we have the penal law, the public health law, all of those abuse, mistreatment, and neglect statutes were from the public health law. We also do a lot of great work on the civil side under the United States False Claims Act, and that allows us to recoup money. Obviously, that allows us to hold facilities accountable. So we're not only interested in prosecuting individuals for neglect and abuse. Frankly, we're more interested in the facilities that are systemically causing neglect and abuse that really impact not that one person, but everyone in the facility. So a lot of our investigations will focus on that. We could talk about a few of them. In terms of the penal law crimes that are available to my office and to other prosecutors' offices across the state to address the abuse and neglect of individuals, endangering the welfare of an incompetent or physically disabled person, all felonies, assault of an individual over the age of 65 years old, and what I talked about, homicide, of course, manslaughter for recklessly causing the death of someone. We see that a lot, unfortunately and tragically, and this is something that we convey to the caregivers, to really not take those unreasonable risks, those one-person transfers that we just see so often of a direct caregiver, either because they don't have the necessary assistance or they're trying to get through their work too quickly. When they perform a one-person transfer, resident falls, can be severely injured. We have a history of prosecuting those cases, and often they do result in death, which is incredibly tragic, and of course, sexual abuse. We're fortunate in New York that the Attorney General is specifically empowered under Executive Law 6312 to take proof of an instance where there is repeated fraud in the conduct of business. So we can take examinations under oath during the pendency of our investigation. So getting back to those more systemic, those institutional cases, what are some of the things that we're looking for? Well, we're definitely looking for insufficient staffing, which per se leads to poor care. We're looking for lack of training and supervision. We're looking at the staff. Is there enough is there enough registered nurse coverage? The registered nurses doing direct care. We look at the training programs in every case. We're looking at in-service records to make sure that the underlying staff is properly trained in doing their jobs. Of course, overuse in agency staffing. In terms of our historical cases, we're looking at the history, the performance history of a facility, the allegations of neglect and abuse. Is the facility, are they putting Medicaid money to direct care as opposed to taking it out as profit? Medicaid money should be going to direct resident care, not to line the pockets of a nursing home operator. So did the facility maintain basic equipment, supplies for residents? Was there proper bedding, diapers, linens? Did they have sufficient policies or procedures to treat residents? Were they reporting their incidents and accidents? Did they have bona fide internal investigations? These are all things that we look at. We have a history of looking at them where, frankly, the facilities haven't done it. So we're looking at survey history of a facility. Does the facility have repeat survey deficiencies and immediate jeopardies? Is the facility on the special focus list? Has the ownership of the facility, the actual owners and operators, have they received notice about the impact of the owner's reduction in staffing levels or salaries or failure to provide adequate supplies? Has that had a negative impact? Same with insufficient supervision. We're looking at that as well. And again, findings that owners cut and underfunded direct care staffing to divert significant Medicaid funds to themselves. So I can't talk about ongoing cases, obviously, but just to give you an example of how some of these investigations play out. I know that many of you are familiar with these two cases that I'm going to talk about briefly, but just to give you an example of how one incident could develop into a much bigger investigation that really looks at the overall performance of the facility. In Medford, our investigation to Medford Multicare was one of those investigations. The main investigation into Medford started with an incident where a resident who suffered from COPD was required to be put on a ventilator at night. She was not put on the ventilator. Sadly, she was deprived of oxygen, went into cardiac arrest, and passed away. We later learned through a whistleblower that staff attempted to cover up the investigation. So we did an investigation into that incident, but we went beyond that. We looked at the overall performance of Medford. And what we found was a history of staff arrests, survey deficiencies, underreported incidents, staffing cuts, diversion of Medicaid funds. And not only did we indict the facility, including the administrator, for the neglect of that woman, whose name was Aurelia Rios. Her family gave us permission to use her name in these types of trainings. And obviously it was published in newspapers. Newsday covered the case on a regular basis. So what came out of that? Well, the corporation and 9 employees were indicted. All were convicted, including the administrator, the director of respiratory therapists who engaged in the cover-up. The respiratory therapist, she was convicted of criminally negligent homicide after a long trial for failing to do her job, and egregiously failing to do her job. Nurses, LPNs, CNAs, egregious failures that led to the death of a mother of 2, a grandmother of 6. And that's a picture of Aurelia. We also sued Medford under Executive Law 6312, which I talked about, under the New York State False Claims Act and the Federal False Claims Act, social services law, and common law actions. So under New York State law, we're allowed to enter into compliance agreements with these facilities. And in Medford, we entered into what's called an assurance of discontinuance, which is the legal mechanism by which we can have a compliance that we can monitor over a course of several years, require them to have higher levels of staffing, to put their money where their mouth was, to put aside $6 million that would go specifically to resident care, and to have an individual financial monitor the use of those monies. They paid back Medicaid $10 million, and the monitor was also part of the governing body of the facility. So the key to our investigation and prosecution at Medford was obviously to hold everyone who was involved in the death of Mrs. Rios accountable for her death, and to vindicate her rights and the rights of her family, but also to ensure the future safety of residents and future residents. And these are a couple of other aspects of the assurance of discontinuance. Another case was the Focus rehabilitation case up in Cooperstown. It was a really tragic situation of what looks like from the outside to be a lovely facility, but they had a history of poor care, underreporting incidents. And in 2016, they just had one of the most egregious incidents that I have ever heard of, doing this quite some time. They left a 94-year-old woman in a chair unattended for 41 hours. So in that case, 4 members of the staff were convicted of falsifying medical records. The owner and the manager of the entity that operated the facility were also, for the historic neglect and abuse that occurred at the facility, were convicted of endangering the welfare of an incompetent physically disabled person. Paid back $1 million. They were banned from operating any healthcare provider in New York, so they're out of the program, which is where they belonged, and they were required to divest. So what has Monfuku been doing during COVID-19? Well, as I indicated, we've successfully transferred from an office operation to telecommuting. It's been very successful. I'm happy to report. We started a COVID-19 hotline that was very active. And I'll talk a little bit about that in terms of really being a place where folks, families could go to get help, especially during those peak moments of the pandemic. And we've been very closely coordinating with the New York State Department of Health that has been so active going out into the facilities and doing infection control surveys. So these ways of getting in touch with us regarding COVID-19 reports, please take note of them. Please pass these on to your contacts in these facilities. Of course, we have a toll-free number. Actually, we have multiple toll-free numbers. And then we have, that's our COVID-19 hotline number. And then, of course, we have a website with an online presence that you can go to as well. And that's what it looks like. If you go in, you can give us the basic information and someone from my office will follow up with you. And we do follow up. And we follow up quickly because we know how quickly sometimes we need to move on these cases to ensure the safety and protection of the residents. So what are the most common COVID-19 allegations? I can't talk about ongoing investigations, but of course we've heard about poor communication with the families, which was incredibly tragic. And the way that we look at poor communication is not only as a customer service aspect, but facilities are required to, under the state and federal regulations, to notify resident representatives of any information that could affect the care that that resident is receiving. So it's more than just bad service. It goes directly to the heart of an individual's right to choose and an individual's right to participate in their healthcare decisions. So we take them very seriously. We fielded a lot of communication about the facility's failure to communicate with families. We understood that a lot of facilities were stretched incredibly thin, but we reminded them that it's critically important and really at the heart of their care obligations to the residents and the residents' families. Concerns about lack of infection control, of course, and staffing as always. So at the beginning of the pandemic, we saw a lot of tragedy. We saw, and that was tragedy on both the caregiver side and of course the resident side. So we worked with the nursing home sector. You know, I will not refer to it as an industry. I call it the nursing home sector. Industry just doesn't seem humane. But we facilitated the resolution or contact with the families. If the families couldn't get through, we were calling up the facilities and reminding them of their obligation. And fortunately, I can report that the communication did happen. If it didn't, we would follow up with a more formalized cease and desist communication. We were also assisting facilities with getting PPE and getting staffing. Unfortunately, it didn't always work. We didn't see what we wanted to see. So there are ongoing nursing home investigations. And what are we looking at? Well, you know, as the New York Times reported, deaths in nursing homes were not inevitable from COVID-19, and that's our starting point. So the questions that we're asking: when there were COVID deaths in a facility, did the facility act in good faith? Did the facility adequately prepare and sufficiently invest in equipment, training, and staffing to avoid tragic results? Did the facility hold the line on their fundamental obligation to ensure infection prevention and control? Did the facility appropriately put money towards resident care? So those are the things that we're doing now. And our folks, the folks in the Medicaid Fraud Control Unit, are incredibly passionate about the work that we do. The work is essential, and we really are honored to do it. It's a privilege to vindicate the rights of vulnerable residents who have no one, who have been mistreated, abused, and neglected. We protect the financial integrity of the Medicaid program to ensure that those limited resources get to where they need to go. And of course, we address fraud in protecting nursing home residents, current residents, and residents in the future. So we can't do it alone. In order for us to be successful, we need the assistance of the public. So please always feel free to contact me. I know that there's probably several people on the phone or on the video that have contacted me. If you do, I can assure you we will address your concern. Contact me directly or contact the unit. We're always available. We're always happy to assist. I'd just like to say to everyone, please stay safe. It was an honor for me to participate in today's program. So thank you to Richard, thank you to the LTCCC, and best to all of you as we continue to fight through this pandemic. Thank you.
Tom, thanks so much. That was excellent and so useful and very informative. Everyone, we're going to take a break for 5 minutes, and when we come back, Deb Trahowski will be speaking. So we'll start again at 10:55. If you want to grab a cup of coffee, etc. Thanks so much, and Tom, thanks again. That was really extraordinary. A lot of questions. While we're on break, I just also want to quickly remind everybody that to please put any questions that you have for the Q&A in the Q&A, not in the chat. We're only going to be taking questions from the Q&A. We have a lot of them already, so I'm looking forward to that. And also, we are recording this and it'll be available on our YouTube channel. There's links from our website, and I think you should be able to view it from our website as well by next Monday. So we'll have that up there as well. Thank you.
Thanks, Richard. And those of you attending, you also get an email in a few days with the link to the video and other resources from today.
Hi, everyone, and welcome back. Thank you, Eric. Eric is changing our screen, and I'm going to start sharing my screen for Deb Truhowski's presentation. Welcome, Deb, and thanks so much for joining us today. Just give me 1 second, and we will get that up. There you go. Can you see that?
Yes, thank you so much, Richard. So glad to be with everyone here today. Richard, thank you for that wonderful introduction before. And I appreciate very much both Tom and Richard's presentations. They were extremely informative. As echoed today already, I feel that there could not be a more important time for this symposium with all that has gone on this year with respect to nursing homes. As Richard mentioned, I'm going to be speaking about elder care, neglect, and abuse. And I want to begin with ways to identify abuse and neglect. And I like to look at it as a 3-step approach of look, listen, and smell. With respect to looking, look, is a resident well cared for? For example, is their clothing clean? Are they bathed? Are their fingernails cleaned? Also, listen. What is the resident saying in terms of their situation? Do they have complaints as to the care they're being given, or regarding a specific staff person? When visiting, and I know right now that unfortunately isn't happening very much, but when visiting, do you hear other staff people yelling at a resident or being verbally abusive? Is there a change in terms of the residents' interests or activities? And again, I know some of these things are not possible to observe right now, but just important things to think about. When I think about the look and listen approaches, what comes to mind for me is a particular case that I handled a few years back. And in that particular case, a granddaughter was the healthcare agent for her grandmother. And when she would visit, she was noticing bruises that were on her grandmother, first on her arm and then on her hand. And so she asked her grandmother what happened. And her grandmother actually made a hitting motion with her own hand. And this concerned, of course, the granddaughter. And also, while the granddaughter was visiting, she heard from across the hall a staff person yelling at another resident, so much so that she actually went to the door to find out what was going on. Based on these concerns that she had from looking and listening, she put in a hidden camera in her grandmother's room. And unfortunately, her worst suspicions were confirmed that her grandmother was being abused, and actually by this aide that was yelling at another resident across the hall. And so as a result of her being so observant, she was able to stop something before it became even worse. The other approach is smell. And I know sometimes people will feel like, well, it's a nursing home, it's going to smell. But no, that's absolutely not the case. Yes, there may be an occasional accident, but there shouldn't be routine odors of urine or other foul smells that one is sensing. And as I mentioned, I realize that right now with visitation so limited that at first thought it might be, well, how can we do these things? But there are opportunities in the limited ways that visitation is presently allowed, even through a window visit. Someone could be observed, or through some type of Skype or Snapchat or some type of, not Snapchat, excuse me, some type of chatting with the resident. Questions can still be posed to try to get as much information as possible. Next, I want to speak about regulations and statutes. And I know they've been touched on or dealt with by Richard and also Tom, but I also want to just mention this as well, because what is so important, and as Richard, I think had said this as well, that in empowering people, residents, ombudsmen, advocates, it's critically important to know that there are statutes and regulations that speak to the level of care that should be given to residents. And that is a source of power to know this. So as mentioned, there are federal statutes, and the Nursing Home Reform Act, also known as OBRA 1987. Also, there are federal regulations that establish specific standards regarding nursing home care. There are New York State statutes, specifically the Public Health Law Section 2801D, and I'm going to speak a little bit more about that. There are also New York State regulations with respect to nursing home care, adult home care, and even home care type of care. As I mentioned, I'm going to speak now a little bit more about Public Health Law Section 2801D. And this is such a powerful statute for those of us here in New York. And I'm just going to read a little bit as is in the slide with respect to what the statute says, because it is so powerful. So basically, any residential healthcare facility that deprives any patient of any right or benefit shall be liable to the patient for injuries suffered as a result of that deprivation, except as hereinafter provided. Also, for purposes of this section, a right or benefit of a patient of a residential healthcare facility shall mean any right or benefit created or established for the well-being of the patient by the terms of any contract, state statute, code, rule, or regulation, or any applicable federal, state statute, code, rule, or regulation. What's so important about this statute is that it is, in essence, burden shifting. And if a resident is injured in a facility, or God forbid, dies because of some type of poor care, the facility is liable to that resident for this injury or, God forbid, death, unless they can plead in their legal documents and prove that they exercised all care reasonably necessary to prevented and limited that injury. In speaking about statutes and regulations, it's also important right now to address what we sort of label as immunity legislation in our state, because due to the pandemic, this immunity legislation does now presently exist. And I'll just give a brief history to understand what has happened with immunity during this period of time of the pandemic. On March 23rd, Governor Cuomo issued Executive Order 202.10 that basically afforded medical providers immunity from civil liability for any injury or death that occurred as a result of an act or omission by that medical professional in the course of providing medical services in support of our state's response to the COVID-19 outbreak. When this executive order was passed, there was uncertainty as to which providers or facilities were covered or included, and what actions or activities were included. The New York State legislature then passed the Emergency or Disaster Treatment Protection Act on April 2nd of 2020. And certain terms were defined. For example, healthcare facilities, for purposes of what we're discussing today, were defined to include nursing homes. So immunity was granted to nursing homes based upon this act. And also healthcare professionals were defined to include nursing attendants and certified nurses' aides. Also, immunity was now afforded for criminal liability as well as the civil liability that it was included in the executive order. And activities were expanded to include not only providing services, but also arranging for healthcare services. After a very strong outcry regarding this very broad legislation, on August 3rd, Richard, thank you. On August 3rd, the governor signed the New York State Legislature bills 8835 and 10840 into law. And with the governor's signature, he thereby amended the immunity provisions that were enacted in the Emergency or Disaster Treatment Protection Act. And immunity was now limited to healthcare professionals who were providing diagnosis or treatment or care for confirmed and suspected COVID patients. What's important with this change is that immunity will no longer apply to the prevention of COVID-19 services, or the care of non-COVID patients, or the arranging of healthcare services. So this was a very important limitation. This legislation, though, however, or this change was not retroactive. It was effective immediately, but only prospectively to cases accruing after this change on August 3rd of 2020. On the federal level, Senators Cornyn and McConnell have introduced an extreme COVID immunity bill, and we're pushing to include this bill in the stimulus bills. Prior to the election, it did not appear to be moving, and it's uncertain what will happen now, but if passed, this federal immunity legislation would have been catastrophic for nursing home residents. What I want to speak about now is the analysis of care. And when looking and evaluating care that is given to a resident, there is a certain analysis of that resident's care that should be done pursuant to federal and New York State regulations. And it involves basically a repetitive analysis. The first step is assessment. When any resident comes into a facility, a thorough and complete assessment needs to be done of that resident to determine that specific resident's needs. For example, is the resident a fall risk? Is the resident at risk for developing bed sores? Or are they at risk for malnutrition? And then importantly, based upon that assessment, a care plan needs to be established that's individualized to that particular resident that addresses their risk factors. And that care plan needs to have specific interventions detailed that would address the risk factors, as I just mentioned. Then, most importantly, after having a good assessment and an appropriate care plan, those interventions that are set forth in the care plan need to actually be implemented. For example, let's say that a resident is determined to be at risk for developing pressure ulcers, and a care plan is established that includes interventions for the prevention of pressure ulcers, for example, turning and positioning. What's important is that when looking at the actual records for that resident, that turning and positioning was done. Because if it's assessed and care planned, but not actually implemented, it doesn't do that resident any good. What's also important is that that care plan is updated, because a resident's condition today may not be what the condition is a month from now or 6 months from now. And also, when a resident, if there is a change in condition, there needs to be an assessment, a reassessment and care plan. If someone falls and has a fracture, they're now in a different position than they were before. Or also, for example, with an Alzheimer's patient, that individual will come in with certain abilities, but unfortunately, based on the disease, their condition is going to change. And the care plan needs to be updated to reflect their ongoing needs. I'm often asked, well, okay, we have these statutes, we have these regulations, but what actually can be done? What cases are you seeing and what cases are you bringing based upon what our rules and statutes and regulations set forth in New York? And so I'm just going to speak about 3 different types of matters that we handle. And the first is pressure ulcers, also known as bed sores or decubitus ulcers. They all mean the same thing. And unfortunately, we see far too many situations with residents having bed sores. What's also disturbing is that it's often that a family will not know that their loved one has a bed sore until that bed sore is often in an advanced stage. And bed sores are staged 1 to 4. 1 being the least beginning stages and 4 being the most serious. We often hear families tell us, well, my mom or dad, for example, was transferred to the hospital because they had an infection. And the hospital was the first one to tell us that someone had a bed sore, that my loved one had a bed sore. When thinking about that, I think back at the 3-step approach I was mentioning before with look, listen, and smell. And based upon that approach, I'd like sharing some ideas of how a bed sore may be able to be identified sooner as opposed to later. And this shouldn't be necessary. The facility should be communicating that there is a bed sore because that would be a change in the person's condition, and that should be discussed and the family advised, specifically the healthcare agent. But since we do not see that happening all the time, that's why I do want to share these things with you. So for example, with look, and again, this is more feasible when hopefully visitation can go back to a more normal state. But look, when I refer to that, what I'm referring to is often when someone's being changed, they're asked to leave the room. And many, many times families will say to me, well, I was told that there's a rule that I have to leave the room when my loved one is being changed. And I want to make it clear that there is no rule that exists out there that someone has to leave the room when someone's being changed. If someone is either the healthcare agent for an individual or the surrogate decision maker under the Family Healthcare Decisions Act, or if the resident says it's fine for my son, my daughter, or my friend to stay in the room, the person can stay in the room. And what's important to look at is the parts of the body that aren't typically visible, because bed sores are happening in the areas we don't typically see. For example, the low back, the sacral area, the coccyx area, the hips, the buttocks, the heels. And if someone is in the room when someone's being changed, they can view the backside area to make sure that there's no redness, there's no skin breakdown going on. Also, the other component of listen. If a resident is complaining of pain, for example, in their low back area, sometimes we may just think, oh, it's arthritis, and it may be, but it may not be. Bed sores can be painful, and that could be a source of the pain. Also, the other criteria of smell. If a bed sore has become infected, there can be a foul odor. So that's something else to look out for. And what I want to very happy to say is that there are regulations that address bed sores, both at the federal and the state level. And at the federal level, there is a regulation that is, as the slide is before you, 42 CFR 483.25B1, that specifically deals with bed sores. And the language of the regulation is very strong. It says the facility must ensure, and that's a powerful word, that a resident receives care consistent with professional standards to prevent pressure ulcers, and that someone doesn't develop them unless their clinical condition demonstrates they're unavoidable. Also, the second part of that regulation, that a resident with pressure ulcers receives the necessary treatment and services to promote healing, to prevent infection, and prevent new ulcers from developing. The second component comes up in our practice sometimes. Facilities will sometimes say to us, well, someone came in with a stage 2 bed sore, for example, and what can we do? Well, it's very clear what should be done. That ulcer, they should take all steps to heal that ulcer and prevent other ulcers from occurring. Sometimes people will say, well, what can be done? People are going to be lying on their backs or in wheelchairs, and bed sores are inevitable. Well, there are several interventions that can be put in place in order to attempt to prevent any type of skin breakdown that's occurring. For example, as I mentioned before, turning and positioning someone who can no longer turn and position themselves. Also, providing pressure reducing or relieving devices such as mattresses and chair cushions. Also, proper nutrition, proper hydration. Also, changing a resident on a timely basis. And if someone does have some type of skin breakdown, to limit the time that they spend out of bed, to not be, let's say, in a wheelchair for 8 hours a day, especially if someone has skin breakdown already. Another area that we often see, unfortunately, are falls, and falls ultimately resulting in fractures. But importantly, before often that fall with a fracture, there are other falls. And it's very common in a lot of the fall cases that we handle that someone had fallen multiple times before, and the facility would call and say that there's no injuries, which thankfully is very good. But that is a sign, that is a warning, that is an indication to see, are all appropriate interventions being used to try to prevent that fall where someone does actually sustain a fracture. Also, even when there aren't falls that a family is aware of, sometimes families will see that someone has unexplained bruising to their face or to their body, and that's something to be investigated. Could it be that someone is on a blood thinner and they're more sensitive? Yes, but it's also important to investigate that it's not due to any other reason. And I'm happy to say there is a federal and state, there are federal and state regulations that also address falls. And as you can see through the slide, it's CFR 483.25D. And this regulation, as the same with the BEDSO regulation, is strong. Facility must ensure that the resident environment remains as free of accident hazards as is possible, and also that each resident receives adequate supervision and assistive devices to prevent accidents. And similarly with bed sores, I will sometimes hear people say, well, people are older, they're frail, they're going to fall. And yes, people may fall, but what's important is, and as what the regulations require, is that the appropriate devices and supervision are in place to attempt to prevent falls. And some examples of what those interventions can be are bed or chair alarms, a lower bed or a low bed, mats, if appropriate for the resident, toileting schedule, keeping someone near the nurse's station, for example, if someone is awake in the middle of the night. And what families have said to me on a really all too frequent basis is that if they are visiting, again, pre-pandemic, and they're concerned that their loved one isn't being changed or the facility isn't being responsive, the staff is just saying, well, we don't have enough staff. And I have to say, in my many years in practicing in this area, I didn't used to hear that, but over the last few years, staff have just been saying that. And I feel like that's a bad state to be in, that the staff is just saying that. And it's unfortunate the pressure puts on the staff that is working, but it's not an acceptable answer that there is not adequate staff. And the final area that I was going to discuss in terms of examples is when someone has had significant weight loss and it's impacting their ability to really function and to have quality of life, or when someone is severely dehydrated and it can result, if not rectified quickly enough, in some type of permanent kidney damage, for example. What I'm here to say is that weight loss, malnutrition, dehydration, these are not necessarily just part of the aging process. For example, I've had circumstances where families will share with me that they went to visit and they saw the food tray just far enough away that their family member couldn't reach it, or that the tray is just partly eaten from, and staff just isn't taking the time or doesn't have the time to actually help the resident eat. I mean, it's just heartbreaking to think that someone isn't being fed, and those are signs of neglect and unacceptable. Similarly, I'm happy to share with you that there is a regulation at the federal level as well as state level that deals with nutrition. And as you can see from the slide, it's CFR 483.25G. And the same language, the facility must ensure that a resident maintains acceptable parameters of nutritional status, such as their usual body weight, electrolyte balance, again, unless the resident's condition demonstrates it's not possible. Also, that the resident is offered sufficient fluid intake to maintain proper hydration and health. And also, if a therapeutic diet is ordered, that it is offered to the resident. Going back now for a few moments to our New York State statute under the Public Health Law, Section 2801D. And it was such a well-drafted piece of legislation. And I'm just so thankful that we have this statute here in New York. When our legislators drafted this statute, they were aware that a lot of people in nursing homes are on Medicaid. And they wanted families, residents, to use this statute to hold facilities accountable so that the quality of care would be improved in the state of New York. So they included this subsection, it's subsection 5 in the public health law, and it speaks to the impact of a recovery on future Medicaid eligibility. So if someone brings a lawsuit and there is a recovery, a settlement, or a verdict, and they receive monies, this particular section addresses that. And it basically says that the amount of damages recovered when someone brings a claim under this section will be exempt for the purposes of determining initial or continuing eligibility for Medicaid. Also, that in the second component, that recovery will not be taken into consideration or required to be applied towards the payment or part payment, basically of past Medicare benefits that were received. Another well-crafted section of the public health law is subsection 10. And we refer to this as the whistleblower protection section. And what it basically says is that if a patient brings an action under this section, that the facility cannot discriminate against that or retaliate against the resident for bringing this action against the facility. Also, that if a resident or an employee testifies as a result of this action, that they also cannot be discriminated against for doing so. I've discussed ways to identify abuse and neglect. And now I'd like to share some thoughts with you as to ways to prevent abuse and neglect. And these are some things that we advise families of residents, we suggest that they do. One is to be involved in the resident's care. And again, I understand right now that may not seem that possible, but it still is possible in the ways that are available to families to participate and to visit with their loved ones. It's important to ask questions of the staff. Also, as I mentioned before about not leaving the room, again, when visitation hopefully is back to normal, I just can't emphasize enough the importance of that. Also, asking questions about the residents' diet, their activities, their medications. When families have asked for medication lists, for example, it's not uncommon for them to see that their loved one is on a medication that they weren't aware of. And sometimes there's a good explanation for it, but sometimes there isn't. And so it's just another way of a checks and balance to understand what's going on and to make sure that the resident's care is as effective as possible. Also, asking for a copy of the care plan. That's within the rights of someone who's a healthcare agent, or as I mentioned, surrogate decision maker, or again, if the resident says it's okay for my son or daughter or friend to have a copy of the care plan. Also, to participate in the care plans. I understand again that visitation is very limited, but I've had families that have participated in the care plan meetings by phone. And so I would highly recommend that, especially now. If after asking questions, you feel that you're not getting answers and you feel just stonewalled, just keep going up in terms of asking to speak with people. Ask for the supervisor, ask for the director of nursing, ask for the administrator if you feel that your answers are not getting addressed and you have concerns. And go with your gut instinct. If you have a gut concern that something is wrong, follow through with that. The best case scenario is that you're wrong. Also, it's important to know about when visiting, again, when visiting goes back to normal, hopefully, visiting different times of day. When someone goes the same time every day or every week, the staff is not is aware of that usually. And so it's good to go different times of day, different days of the week, to try to get as clear a picture of the actual circumstances as possible. There are also excellent websites in addition to the resources LTCC has. There are websites to find out information through Medicare and the Department of Health websites about complaints, inspections involving the facility, also quality indicators at the different facilities. What is so important with respect to a program such as this is that we can concretely address how we can work together to improve the quality of care in nursing homes. And it's so important for residents and advocates and family members and ombudsmen to be empowered when they go out to advocate for someone and to be aware of the services that are available to them. And so just as a reminder that there's the wonderful Ombudsman program, there are family councils for family members to join forces. They're filing complaints with the Department of Health, as well as Tom's unit, the Medicaid Fraud Control Unit. Again, a reminder, there are these federal and state statutes and regulations that are the backbone of why they should be providing this proper level of facilities, providing this proper level of care. And there's also this ability to pursue public health law claims. In my opinion, the more these claims are brought through the public health law and that the rights and services that are available to families are utilized, the greater is the likelihood that facilities will improve their quality of care. Based upon the work that we do in my firm and the cases that we bring, our goals as a firm are to effectuate systemic changes in facilities so that the abuse or neglect that one family is experiencing and resident is experiencing doesn't happen to someone else. And that's often what our family members are asking us to do. They don't want another family to experience what they've had to go through. And through these systemic changes, the hope is that it will improve the overall quality of care at facilities. We also strive to maximize the compensation that that resident will receive if they've been injured or, God forbid, killed as a result of neglect, because it will send a strong and powerful message to the facility that this is unacceptable. Also, we welcome residents and family members to contact us if they have questions, to visit our website, which is on the slide, yournyadvocate.com. We have the answers to frequently asked questions on our site, as well as other topics. And again, just by empowering residents and families and ombudsmen, and by holding facilities accountable, the goal is that this will increase the overall quality of care. I thank you so much for your time, for your attention, for the opportunity to be here with you today, and that everyone stay safe and healthy during these challenging times. Thank you.
Deb, thanks so much. That was really excellent. I appreciate it. And I just wanted to tack on to what Deb was saying, and also kind of to what Tom was saying also about the litigation that Tom and Fuku do, and that Deb does, and others do to represent residents and residents' families. The reason why this is so important to us as advocates at the coalition is that what too often happens is that nursing homes are not penalized for violations. So even when, they may have ongoing citations, they may not have any citations at all, but they're still violating some of the resident care standards that we talk about today. And if there's no penalty associated with a violation, including, resident neglect or resident abuse, if there's no penalty associated with a violation of those standards of care, it in essence sends a message to the nursing home industry that that level of care, that substandard level of care, is okay. So it's really important to us to send a message through the Medicaid Fraud Control Unit, through Deb and others who represent residents when there is harm, and when there is suffering, that that's not okay. And the way to do that, as Deb was saying in the work that she does, is to ensure some accountability, ensure that those residents are heard, there's accountability for their care, and that there's a message that then goes to that nursing home and to other nursing homes that poor care is not okay. And that's really, really the baseline, and again, why it's so important to us. Eric, I think if you could stop oh, actually, I guess it's me. Sorry. Let me stop sharing my screen. Thank you. And it's 11:31, so we finished a little bit early. Why don't we take say a 9-minute break, and I'll start at 11:40 with with actually our last panel, which is me. I'm going to talk about some of the resources that we have for residents and families, and for ombudsmen, and for advocates, people who are working and advising residents and families on what they can do to support their advocacy. So thanks, and we'll be back again in about 9 minutes. Hi, everyone, and welcome back. This is Richard, and we're going to get started with our last program, our last panel of the program today. And I just want to again thank Tom and Deb so much for their excellent presentations. As you can see, it's not our job, and certainly not our goal to penalize facilities, but we do want to see good care, and we do want to see implementation of the rules, realization of the standards of care, the good quality of life, good quality of care that every single resident deserves, that we pay for mostly as taxpayers. Taxpayers pay for most nursing home care through Medicare and Medicaid, as I mentioned at the start of the day, that care that's provided is humane and that is focused on the resident as an individual. That's what facilities promise to provide, and that's certainly what everyone deserves to have. So I'm going to, there we go, share my screen. And just, well, there we go, slideshow, play from start. Thanks. So thanks again and welcome back. Again, this is Richard and this is our last panel for today. And then we're going to have a open panel discussion with Q&A joined by Claudette Royal, our New York State Long-Term Care Ombudsman. And what I'm going to talk about is some of the resources that we have compiled on our website to support resident-centered advocacy. As Deb mentioned, there's good information out there from Medicare.gov and from New York State. Every single state must have a nursing home quality and information website or webpage or portal through which you can find information about nursing home care. I tend to use the federal website the most. I think it tends to be a bit better than the state websites, frankly. But you can find a variety of information. We actually, I think, have links to those as well on our website. But what we do at LTCCC is we provide some specific information and resources on our page. So this is a picture of our website now. We just redesigned it, and I'll give a little shout out to Eric Goldwine, who has been the master behind the presentations today for this program, but also has been redesigning our website to make it more user-friendly and readable. So we are in the midst of doing that, but you can see we've redesigned the platform, and hopefully you can see we have up here information. Actually, you can, right at the very top, you see the F. That is a link to our Facebook page. Next to that is a little icon to go to our YouTube page, and we have some excellent podcasts that Eric has been doing, and the next two icons there are links to, I believe, Spotify and Apple Play, or Apple Podcast as it's now called. And lastly, we have a Twitter feed, LTC Consumer. You can, of course, donate to us. We're a nonprofit organization. We always appreciate that. And then a little search box to search the website. But I want to talk about some of what we have and that we're working on getting these resources to you in a way that is even more user-friendly, more easy to find. There's a lot of data there. As Tom had mentioned, a lot of the work they're doing at the Infuku is using data, and we've been doing that as well. We've been advocating with the federal government in particular to require better data, better information from nursing homes on who the residents are, the quality of care that's provided, staffing, as both Deb and Tom noted, is absolutely essential. And we have some much better data on staffing that is out there. And so we've been working here at the Coalition on how we can get that information to you and to members of the public in a way that is as useful and effective as possible. So this is just the homepage of our website. And what I did was I took a picture here of our learning center. We've been compiling for the last several years a lot of different information and resources here. We actually started, we've had this project with the New York State Health Foundation, as I mentioned at the start of the program. They are funding and supporting this this program, the symposium, so that we're able to make it free for people. And again, it'll be recorded, it is being recorded, excuse me, and it'll be available on our website and on our YouTube channel. But they have also supported a lot of our family and Ombudsman Resource Center work, which I'll talk about in a bit. And prior to this project, we had a project that was funded by the Fan Fox and Leslie R. Samuels Foundation. You can see here the first, second, third, fourth, fifth, sixth, seventh box down, the Dementia Care Advocacy Toolkit, which was done with work with some of the family councils here in New York City, where we're located. And so we thank those family councils. I won't mention the nursing homes names. And that, again, working to see, we're really focused not just on the policy advocacy, but also empowering. How can we help families? How can we help residents? How can we help ombudsmen be as informed as possible with useful information and tools? So here you have really our Learning Center is the place to find it all in terms of resources that can help you, find out the information you need, find the support for the rights, residents' rights and standards of care that you need to support your care, information about our webinars, both past and future, handouts, as I mentioned before, the Dementia Care Advocacy Toolkit, our Family and Ombudsman Resource Center, our Abuse, Neglect, and Crime Reporting Center, as well as our podcasts. So since we're focused today on abuse, neglect, and crime reporting, this is a link to, this is our page, excuse me, on abuse, neglect, and crime reporting. We have a link here to a recent podcast that we did with a reporter who did investigative work out in Minnesota on elder abuse. Very, very interesting and informative and useful to all of us, no matter what state we're in. But we have here, as you can see, these are some of the buttons on the right-hand side, easy links to some of the, first of all, our report with information about addressing abuse, neglect, and suspicion of crime against nursing home residents. We did a study on this in 2019. Links to, as I mentioned before, all of the state agency contacts and complaint forms for every single state in the country. We have links to the state Medicaid fraud control units for every single mfuku in the country. We have, as I mentioned before, when I was presenting, we have our list of definitions of nursing home abuse, neglect, and crime. We have a form for investigating resident injuries or suspicion of a crime against a resident, et cetera. So here is the link to the, and I just copied, just spotlighted these two pages. This is the, if you go to the link to the state agency complaint forms, you can see here, you can, and I apologize because I mixed them up. Sorry about that. So on the right-hand side, and I'll correct this when we post the presentation, on the right-hand side, you can see the link to the state agency complaint forms on Medicare.gov. Sorry for my confusion. And then on the left-hand side, you can see the link to the state Medicaid fraud control units. So either way, and what we're trying to do again is just give you a very easy way to access through nursingHome411.org all the resources, whether they're resources that we have or resources that are available elsewhere, where you can go to file a complaint, to raise a concern, to get help, etc. This is our report on, again, addressing abuse, neglect, and suspicion of a crime against nursing home residents. We were concerned, frankly, as I mentioned when I spoke earlier this morning, that the Affordable Care Act, the so-called Obamacare in 2010, required that every single person who works in a nursing home, whether they be care staff, administrative staff, whether they're coming in providing services, therapy services, or medical services as a contractee of the facility, whether they're providing there to provide laundry services, et cetera, or janitorial services, that they have a responsibility to report any suspicion of a crime, and that there are significant penalties for failure to report, up to $225,000 approximately, for failure to report within 24 hours if the resident has not suffered harm, but if there has been a suffering of resident harm and that's been exacerbated by the failure to report, it could be up to about $340,000. It increases every year for inflation. That is a hefty sum. That's not just a slap on the wrist. So to us, this was really valuable. We had advocated for this in 2009 for its inclusion in the Affordable Care Act. It was included. And our concern when we did this report in 2019 was that not a lot had happened to make it, to implement it in residents' lives, that there had been very little to no enforcement of those requirements. And that as a result, too much resident abuse, neglect, suspicion of crimes against residents were not being reported the way they are required to be. And this continues to be a major challenge for us and something that we'll be working on, and it's part of our advocacy in the coming years. But what we did was we looked to see, one, what those requirements are, and also to see whether there are any promising practices out there. So this is what is included there. I just included the table of contents, but really to see, what is going on? How do we get at this issue, which has been going on for many decades, abuse and neglect and crimes against residents? It continues to be, as you all know, I'm sure, that's why you're here, and that's why I'm here, is it continues to be a major challenge and often, frankly, a heartbreaking challenge for us. This is, as I mentioned before, when I was talking about definitions of abuse and neglect and crimes against residents, this is our fact sheet with those definitions. So when I was talking before about, you don't need to memorize the things that we talk about in our programs because it's all there. And what I really wanted to do before is to plug in with you on, look, we know what abuse is. We know what physical abuse is, what psychological abuse is, what emotional abuse is. And here it is. So you can have this, you can use this in your facility. As Deb said before, we also recommend that if you have an issue, you have a concern, that you start at basically the lowest level in the facility and you work your way up and you hope that it's resolved. Maybe it's resolved by the nurse on duty, and if it's not, by the director of nursing or the administration. And if they're not responding in a timely and effective way, going to the State Department of Health, going to the Medicaid Fraud Control Unit, perhaps speaking to an attorney if it's a serious situation, et cetera, et cetera, et cetera. So it's really important. Again, we have a lot of those. As I noted in an earlier slide, we have a lot of resources for you to connect easily with those entities through the Learning Center at Nursing Home 411. So this is our Family and Ombudsman Resource Center. This is something else that we were able to put together with the New York State Health Foundation funding. So we have a lot of different fact sheets here. We have forms and tools for resident-centered advocacy, which I'll speak about a little bit more. We have handouts on key nursing home issues. Again, you could use the search tab at the top of the website to search for some of these things. So if you're concerned about pressure ulcers, for instance, as Deb was talking about, or you're concerned about the staffing, as both Deb and Tom spoke about, you can search staffing in the website and see all the different information, all the different pieces that we have. We also have links here. We started during COVID-19 to have a Zoom room for family council meetings. So people can reserve a Zoom room, and they could have their own private family council meeting. And there's, in the third paragraph here, you can click to request an appointment, or on the top button on the upper right-hand side here, under the picture of the two ladies, you can click there to request a Zoom meeting. And we're really happy to make that service available, because I know that family members, of course, because they can't meet in a facility as they normally would, are having a hard time connecting. There are some good resources. I was speaking to a family member last week, actually in Kentucky, who had contacted us about wanting to start a group. And I recommended looking on Facebook. If you're on Facebook, you could do other searches online, but I find that Facebook tends to have a lot of information, a lot of resources for families in different areas. So you could connect to family members in your facility, perhaps, or in your community, or in your state. And there's a national group of family members as well. We really think it's important for people to be able to communicate so that we can come together as family members, as advocates, to advocate for our residents. Here are some of the forms and tools that we have. Again, I just took a snapshot of the page, so I wanted you to see what you would find when you came to the page. So it doesn't list all of the files. What we did was we put together a variety of tools. As one column is the tools, excuse me, in Word files. The second column is the tools again in PDF files. So whatever is easiest for you to use, you can download these. Some people are better able to use them on their phone, maybe filling out a PDF, or on a tablet device, or on a computer. You are free to use any of these in any way that you like. So they include a resident concern record keeping form, a resident assessment worksheet. As Deb was talking about, if you see that your family member, your loved one in the nursing home has an issue, has a concern, you can ask for a resident assessment and for a care planning meeting. The resident assessment worksheet is there to help you during that assessment process to be prepared and to easily identify. Because I know I'm a healthcare consumer myself, and even though I'm an advocate, it can be very hard to have the wherewithal to advocate when you are on the spot, when you're dealing with medical professionals who have their own time frame, who may be rushing you, et cetera. So the assessment worksheet is there to help you to, the resident or the person working with the resident, the family member, et cetera, to identify things that are important to you or things about which you are concerned. We have a resident preferences form to help residents and their family members talk about who they are as a person, what their preferences are, et cetera. It can be very useful to share personal information because too often, I think, even though most care staff, I think, are well-meaning, because of short staffing, it's very easy for it to become almost a factory-like setting that it enables you to individualize yourself or your resident. It enables you also, for instance, a lot of residents have cognitive impairment or maybe Alzheimer's or dementia, where it's more serious. It enables them to express who that person is, what they find comforting, things that they like and things that they don't like. So for instance, if a resident is becoming upset or agitated, you could list there the types of music, types of TV, the setting that the individual likes that they find soothing or calming. So that's just some of the things that we have on the worksheet. Again, all these things are free to use, print out, share with other families, et cetera. You're welcome to do that. We also put together some materials to help families and residents establish their own councils. So we have a family council meeting notice. We have a resident council meeting notice. I know this is hard now. This may not be as useful now during COVID-19, but these are the types of things that can be shared once we're back in facilities. And hopefully some of us are coming back in slowly, but that we can use more so when we're actually in the facility. Same thing, we have a resident council meeting notice, a family council meeting notice. So if you are working with residents, if you're working with family members, if you are a family member or a resident, you are welcome to use these materials in support of developing your family or resident council. This is the resident preferences form that I mentioned earlier. I think that it might be in its entirety. It might go on a little bit longer, but here it talks about, on the left-hand side, a little bit about me. I prefer to be called, and you could put in the name there. I remember when my aunt was in a nursing home that she preferred to be called by her last name. Too often we hear about residents, that some facilities, every resident is called sweetie or honey. Some people may like that, but a lot of people, especially older adults, may find that disrespectful. So here's a place to say, I prefer to be called. I like to wake up naturally, or around a certain time. This is, as Tom was saying, as Deb was saying, this is the resident's home. We expect care and services to be tailored to fit their needs, not the needs, the schedule, or the convenience of the facility or the facility staff. And that includes having a morning routine, waking up at a certain time, being able to exercise preferences in terms of bathing or showering, as we note here also on the left-hand side. As I mentioned before, music and TV preferences, some things that I enjoy or find comforting, a space to talk about that. So this can be left out. It could be put in the resident's room. My aunt had one on some things on her door, on the inside of her door, so people can see, when they were coming in, what her preferences were. It was right there. A little bit of information on the right-hand side about the individual and his or her family. If people want to include or not, it is, of course, up to the individual what they prefer, but they can talk about what their activities are, what kind of foods they like, whether they like dogs or cats, etc. And here is, as I also mentioned before, the record-keeping form for resident concerns. This I thought was really important because when we started working directly with family members, and as I mentioned before, we did a project first with the Fan Fox and Leslie R. Samuels Foundation for our Dementia Care Advocacy Toolkit. And what I heard from a lot of families, I remember at that time was, I've been complaining about this problem, X problem in my nursing home for months. And they told me it was going to be fixed, and no one has ever fixed it. And I would hear that a lot, and that is entirely legitimate. However, it's not always easy to act on. So what I wanted to do here is give people something that was easy to use, not burdensome, but for you to use as family members, as residents, etc. But also that could be a good record of who you spoke to, when you spoke to them, what was going to happen, and did anything happen. So here you can see, you just put in the date when it occurred, what the issue was, as much information as you want to provide, who was involved, do you want to jot down any names, or if there are any witnesses, who you spoke to. So you could say, I spoke to Nurse Claire, and Nurse Claire said the response was that she is going to talk to dietary about, as Deb mentioned before, about my resident not getting appropriate food services and looking a bit dehydrated. And then you can note what actions were taken. So if you come back and you visit a week later and you see that the same thing is happening, you can note it again. Maybe it's time then to speak to the nurse on the floor, or to speak to the administrator, or have a care plan. If you're concerned about your resident's well-being, if she or he are suffering, if they're looking like their health is endangered, they may need to go to a hospital. Certainly escalate it as much as necessary, but that you can keep track of that. And there's a second page to this. I don't think I included it here, but which can be used over and over again. So if you're seeing that you are taking action, and the action, or or if you're making a complaint and you're escalating, and that is not having an effect, that you now have a record. So it's not just, oh, I've been complaining about this for months. Again, that is entirely legitimate. It's a serious problem that we hear about too often, but you can say, I complained about this in March. I spoke to Nurse Claire. Nurse Claire said it was going to be taken care of. Here we are 2 months later, and it still hasn't happened. What are you going to do as a nursing home? Or if you file a complaint with the state saying that, look, I've been complaining about this for months, I have a record, I've been told that it's going to be addressed, and it hasn't been addressed. So that is, again, I think a useful resource for people to use easily, but also to support their advocacy. We have an action center on our website. So this has both New York State specific alerts as well as national alerts that can be used by anyone in any state. as well as some resources here. Again, we try to find, try to put in a lot of different places where you can get information. So if you see on the right-hand side, you can go there directly from the Action Center to the Dementia Care Advocacy Toolkit, to the Family and Ombudsman Resource Center, but also you can tell your story, and we use those stories to support our advocacy on on both the state and on the federal level. So we appreciate those who have contributed to the Tell My Story campaign, and we encourage you to use that. But you can speak out about enforcement. You could speak out in support of assisted living residents on the national level. You can, et cetera, et cetera. Safe staffing, of course, is a really important one. Funding for the Ombudsman program, of course, is a perpetual issue, which we're hoping, realizing now, especially with COVID-19, how important the resident presence is, and the resident advocate, the Ombudsman presence, Ombudsman advocacy is, that we can work on that and get some funding. Here is our data center. So we have, everything I spoke about before is under our learning center, but we also have a data center, which, as Tom was saying, there's really good information out there. And as Deb was saying, there are good resources out there that are from the government, either the state government, the federal government. We try to take it a step further here with providing some very specific information that we think can be, that is important in regard to nursing home quality, and that can be useful. So here we have information on staffing, we have information on enforcement actions against nursing homes, we have information on dementia care, antipsychotic drugging issues, big issues which we've talked about in other programs and we'll talk about again, and other nursing home information that is relevant to quality of care. The first one I'll talk about, and really I'm going to spend a few minutes, I think, focusing on this one, is staffing. Now, as both Deb and Tom mentioned, and Deb mentioned specifically, there's a lot of information out there on the federal and the state websites about quality of care. And essentially, on both of those websites, they use the same data, whether it's the state website or the federal Medicare.gov website. They use the same data, and there's three components of those data. One are the results of the inspections, what are called surveys. And so that leads to essentially 1-star rating on the federal system. The second star rating area relates to staffing, and in particular, the RNs, LPNs, and CNAs that are in the facility. And the third rating component are called quality measures. It's a little bit of a misnomer because the quality measures don't generally really relate to quality. They more relate to they're based upon the findings of the assessment of the resident. So as Deb mentioned before, residents have to be assessed periodically and assessed again if there is, or reassessed if there's any change in their care or in their condition. You can ask for a new assessment. When there's a resident assessment, there's something called the minimum data set, called the MDS. And that lists a whole bunch of things, from some very, they're all important in their own way, but things related to whether the resident has developed a pressure ulcer, whether the resident has had a fall, whether the resident has lost control, has become incontinent, whether the resident has become more depressed. There are a lot of different components of the quality measures. Some of them are more valid than others. And I won't get into it too much here. I only have about 5 minutes left before I want to move on to the panel. But overall, as a quality rating for what we're talking about here, the quality measure component, frankly, is not very useful. And the reason for that is because most of the quality measures are determined by a facility. Did the resident become more depressed? Did the resident become incontinent? Did the resident develop a pressure ulcer? As Deb said, facilities may not notice when a resident developed a pressure ulcer for quite some time. So that would mean that their pressure ulcer rating is actually better than it should be. So I pretty much have always ignored the quality measures as a component of the 5-star system of our facilities rating when I look at quality. what I most focus on, the most important information, which is what we're going to talk about here, is the staffing component. And that's really important because due to advocacy of our organization and other organizations, other consumer organizations, many of you know the National Consumer Voice and the Center for Medicare Advocacy, due to the advocacy of consumer advocates, including the long-term care ombudsman programs nationwide, as of 2010, as part again of that Affordable Care Act, nursing homes have had to report or were required to report staffing for every single day of the year for every single type of staff, of care staff, as well as many different types of non-care staff that are in the facility. So I don't want to get into too much. Certainly, if you're interested in doing a program on this, let me know, let us know. You can email feedback@ltccc.org, and there's something that we can specifically focus on. But there's a lot of good information here. In short, if it's not too late, the staffing is the most reliable information because we have those staffing data actually based upon payroll records. So this made much better than the quality measure star rating, much better than the survey results star rating. The staffing star rating is by far the most valuable. So as you can see here, those staffing data, they're reported by facilities, again, based upon their payroll records for every single day of the year, and they're reported on a quarterly basis. So as of now, we have our most recent quarter is 2019, the fourth quarter. We, after the federal government publishes the raw data, we publish them in state searchable files for every single state in the country. We're going to come out this week with the next quarter, which is 2020 second quarter. Facilities were not required to report for the first quarter of this year due to the COVID pandemic. So we'll be reporting some of that information because some of them did it voluntarily, but really the data we're most interested in next is the second quarter of 2020. So that'll be coming this week, but I'm going to show you some data from the last quarter of 2019. And this is what we post again for every single state. Just want to check my time. I have just a few minutes, but here you can see that you can download these files. We have 3 different tabs you can see at the bottom. We have one that's direct care staff, one that is contract staff. So facilities have to report what percentage of their staff are there on a contract basis as opposed to being employees of facilities. Tom mentioned that, and we know as that being important, and we know that's important. There's been a lot of research over the years showing that reliance on contract staff is an indicator or a corollary to poor care quite often. And then we also report the non-care staff, selected non-care staff, not all of them. Again, when this comes out on a quarterly basis, there are well over 1 million lines of data. So we bring this, we put it in state files. You can search the state file, as you can see by column B, by the provider name. So you can look up for your provider. You can look up for individual cities, individual counties, and then we provide information on the average resident census, the number of residents in the facilities, RN hours, LPN hours, CNA hours, and then we also provide, we average out the average total staffing hours per resident day and the average RN staffing hours per resident day. And again, if you're interested in us doing a webinar in the future, focus on staffing, again, we would be happy to do that. I just want to move along quickly, but this gives you information on what is the typical staffing in a facility or facilities in your city, in your county, in your state on a regular basis for that quarter. Here is the non-care staff information. So we provide here, again, the same data. You can look it up by provider name, so you can search for your facility by city, by county, but we provide the same MDS census, and you could see on an average basis how many administrator hours there are in your facility, how many medical director hours there are in your facility? How often was a medical director there? Some of these you can see, some of them have 2.8 hours, so about almost half a day on average at one facility. And some of them have zero. Some of them have on average 0 hours of a medical director time. We have that for pharmacists, dietitian, activities professionals, and social work professionals, because these things are really important. If you have a resident who has dementia, it's really important to see to what extent they have activity staff. It's true for everyone, excuse me, I just want to be careful, but especially for residents with dementia who need that. There needs to be, are there tailored activities? Well, that is quite often dependent upon whether or not there are actual activity staff in the facility. So here is our homepage. I'm closing up. So you can visit our homepage, again, nursinghome411.org. I think many of you know it. We have updates and resources on coronavirus. We have a lot of fact sheets. I spoke about the fact sheet before on abuse and neglect, but we have fact sheets on a lot of different residents' rights. We have, as I just mentioned, data on staffing, data on infection control violations, ratings for all U.S. nursing homes. We generally put them in state files to make them easy to search. We have a lot of forms and tools that I've been talking about. Dementia Care Advocacy Toolkit is really great, I think. And I thank, again, the family members who helped us. And our podcasts are available on Spotify and Apple Podcasts, and I think Google Play as well. And with that, I am going to stop sharing my screen. And we're going to open it up for a panel discussion. And I'm going to welcome to the panel, in addition to Deb and Tom, Claudette Royal, our long-term care ombudsman here in New York. Thank you so much for joining us. And I am going to do the Q&A. So Deb and Tom, you're not sharing your video and you're muted. So if you could just unmute yourselves, please, that'd be great. Oh, terrific, thank you. So I'll do the Q&A for us. Now, one person asked, how do these laws that, and I think especially that Tom and Deb were speaking about, how do they affect residents in assisted living facilities? Is the standard of care different? So I don't know if anyone want to take that. Well, I'll start, sorry, by saying that they are very different. So, and this is something that we have been advocating about. Again, I welcome you to join in our advocacy, and all of you to join our advocacy and to use our resources. But there are currently no quality of care standards for assisted living or adult care homes on the federal level. So they're only based on whether or not, or to the extent to which a state has laws or regulations on assisted living. And we do have, if you look in our report section of our website, we do have a number of resources on assisted living, including some reviews of state laws on assisted living. And it's something that we've been advocating about on the federal level, and hope to do so again, depending upon where Congress is and where the next administration is in terms of supporting that. But it's something we came close a couple of years ago, and then unfortunately leadership in the Senate changed hands, and that went by the wayside. But it is really important. Unfortunately, so the rules are different, but the standards of care, I always argue, are the same. So good dementia care in a nursing home is good dementia care in any setting, whether it be in assisted living, whether you're in your home, et cetera. I know, Tom, I don't want to put you on the spot, but if you have any, in terms of your investigations, et cetera.
Yeah. In terms of the public health law protections against abuse, neglect, and mistreatment, they apply equally to nursing homes and assisted living facilities. The statute, Public Health Law 2803D, speaks to residential healthcare facilities. So they do apply, and the Medicaid Fraud Control Unit also has jurisdiction over those cases. So if anyone learns of neglect or abuse in an assisted living facility and they'd like to report it to the Medicaid Fraud Control Unit, please do so.
Thanks, Tom. Deb or Claudette, do you have anything you wanted to add, or we can move on?
I don't.
I didn't, Richard. You covered and Tom covered it, so thank you.
Thanks. So here, this is very interesting. Someone asked, I'm not going to mention the person's name, and we'll try to get to as many questions as we can. What are the responsibilities of the facility to protect residents from demented residents who come into their rooms and may harm or intimidate them? Facilities often use care plans as redirection by staff or mesh door guards, which frequently have little effect. Do police have to be called when a resident is injured by another resident? Tom, do you want to?
Yeah, no, I'm happy to take that one.
Great.
It is a nursing home's responsibility to properly care plan for those situations and to adequately supervise a resident whom they know to have violent tendencies, to ensure that that resident is not in a position to harm other residents. We do see cases like that. And when you go back to the definition of neglect in the public health law, that the facility is required to provide timely, consistent, safe, adequate, and appropriate care. It would not be adequate care if the facility didn't adequately care plan to ensure that a resident who might be violent, who does act out, isn't properly supervised or perhaps best suited for another facility. And you go back to that other regulation that I cited, that the facility has to be in a position to adequately care for any individual whom it admits. So if the facility cannot ensure that other residents are going to be kept safe, that resident needs to be moved to another facility. In terms of, and we do sadly see cases like this, they can be very, very serious. Absolutely, the police should be called. There will always be an issue as to whether or not an individual can be held criminally liable for this type of violence if they're significantly impaired. But the police should be called first to ensure that everyone is safe. And again, feel free to call my office as well.
Thank you, Tom. And I would just add, I spoke about this in an earlier slide, that what CMS has said, again, the Centers for Medicare, Federal Centers for Medicare and Medicaid Advocacy, is that if there is resident or resident violence or altercation, it is up to the facility to not just have a plan in place, but to make sure that that plan is effective. So that's really important. The next question is, I think, more for Claudette. Please discuss the inherent conflict between the resident-centered, quote unquote, focus of the Ombudsman program and the need to report instances of abuse or neglect. It's my understanding that that if the resident is not complaining about something and authorizing the Ombudsman to pursue it, the Ombudsman must simply drop it. And I'll just add, before I hand it over to Claudette, let me just say that Ombudsmen are not mandatory reporters. Am I correct, right? Yes. Yeah, thanks, Claudette, and I'll hand it over to you.
That was the first thing I was going to say. We are a resident-focused program. So everything that's brought to us, we go and speak with the resident about that issue before we do anything to investigate that issue. If the resident does not share that concern, then we cannot look into it. As for abuse and neglect, we are not mandated reporters. So if a resident does not want us to report something, we can't do that. If the resident's healthcare proxy has been enacted, we'd be working with the healthcare proxy regarding that issue. Along with, if it seems to be something that we could potentially look into another way, if it's not something that we think might be happening to other residents, we may reach out to other residents in that facility to talk about the concern, to see if they're experiencing it and see if we could potentially investigate it in another direction. But at the end of the day, the resident is the center of all of our work. And if they don't want us to report it, we're not able to do that.
Thanks, Claudette. And if I may, I would just add that, as those of you who are familiar with our work, I just have a tremendous amount of respect for individual ombudsmen and for the program as a whole. But the ombudsmen are not the regulatory body. It's really the State Department of Health that's supposed to take that on. And so, as Claudette was saying, the ombudsman role is to be resident centered. So it's important. I know it's frustrating for residents and for families, but that, you know, just the situation and sometimes feeling like there's, you know, where do I go and how do I get to, you know, the help that I need. But it's an extremely important role, but it's a very specific role. And it's, as with the FUCO, of which I would say the same thing, important but specific, it's different from the regulatory authority and responsibility that the Department of Health has. So thanks, Claudette. The next question relates to provisions made for caregivers now, especially during COVID-19. And of course, this is a concern which we have heard a lot. I'm sure that you all have. I know that Tom and Deb touched on it in their presentations. But the individual asked, can a select group of caregivers be permitted to assist family members in feeding and other psychosocial well-being? And I think I'll answer that first, but if anyone wants to chime in, certainly more than welcome. I mean, this is an issue that it's really difficult, as Claudette knows, because she's educated me a lot about this and you know, sharing the directives from the state. These things are unfortunately very fluid, what's going on with COVID-19, as we learn more about over the months about how it spread, concerns, of course, about, as Tom had mentioned, about the impact it has had on residents in nursing homes and other adult care facilities. And now just this morning, when I turned on my phone, there was an alert that there is a potential very strong vaccine against it that, you know, what won't be coming out soon, but, you know, maybe sooner than we all expected. So point being is that there has been a lot of different direction. I know it has been extremely painful and frustrating for family members and for ombudsmen. I know that it's been just plain painful and sometimes deadly, unfortunately, for residents. But to get at the question in particular, the caregiver issue really depends, and I mean, family member coming in and helping a resident really depends upon one, what the state is doing, most of all what of course, the federal rules are, and those have been changing as well. But both the federal rules changed in September 17th in terms of coming in there, you know, having family members come in. The state rules, at least here in New York, have trailed a bit. But a lot of this is really decided on a case-by-case basis within looking at those rules and looking at where the facility is situated in its community, the extent to which the virus is there, either first wave or second wave, et cetera. So a long way of saying, I'm sorry, that there's not really a great answer. A lot of it comes down to working with your facility, but I would say if you're concerned about your residents' well-being, some of the issues that Deb in particular had raised about whether they're getting the food that they need, whether they're hydrated, whether they may be suffering, is, you know, I'm recommending to everyone for who this is appropriate to ask for a compassionate care visit. Too many facilities have interpreted compassionate care to mean only when a resident is at death's door, and that has never been the case. Compassionate care has always been appropriate, and especially been recognized now many times over by the government as being appropriate if someone needs help with eating, if someone is experiencing significant psychosocial trauma or degradation, et cetera. So I would use that as a, you know, as appropriate, of course, as a way to, you know, to get visitation and to get into the facility. Again, as appropriate. And I would lastly just want to say that meeting with other families, having those communications with other families, communicating with your ombudsman program can help you to navigate this with facilities and in your community. So I don't know if anyone wants to add. I know there's not a great answer here as far as I know, but Claudette, did you want to?
Yeah, I just wanted to say that we have, as a program across the state, been successful in some cases in getting those compassionate care visits. So if you do reach out to the program, they can try to assist you in getting those compassionate care visits. We haven't been successful in every case that's been brought to us, but we have had some success in getting into facilities and getting families to see their residents under that compassionate care visits. And the Department of Health guidance on 917 kind of expanded a little bit that definition to try to help clarify it a bit, but we can assist with that and at least try to help you get that visit in.
Thanks, Claudette. I have two questions that I'm going to combine, and therefore Tom, I would say. So first one is, how has your ability to investigate fraud been affected by the lifting of documentation requirements in this pandemic? Governor Cuomo, through executive order and then in the budget, gave immunity to nursing homes and quote unquote relaxed documentation requirements. I would just, there's a second question that kind of relates to this, I'll add, but I would just say that the governor did not relax documentation requirements. That came from the federal government. And that was, so again, everything that the federal government requires has to be implemented by the state. The state doesn't have a choice, but it was the federal government that relaxed documentation requirements. So this person is asking about investigating fraud during, in relation to the lifting of documentation requirements in the pandemic. And the second person is asking, can you be more specific about how abuse investigations have been undertaken during COVID-19?
Sure, two very good questions. In terms of documentation, I believe that there was in the governor's executive order before the EDPTA was adopted as a statute, the immunity statute that Deborah spoke about. There was a provision in it that relaxed some of the documentation requirements. Correct me if I'm wrong, Richard, but that's my understanding. In terms of our active investigations, how do I say this without commenting on active investigations? I could say this: we're still reviewing records. I don't think that we've seen much in the way of providers indicating that records were not available to us because they were not required to keep them. But it is something that we are mindful of. It's something that we're looking at. How have our investigations been impacted? I believe was the question. They have not been as impacted as significantly as I initially feared. Obviously, especially at the peak of the pandemic, our folks were all working from home. A lot of our staff is back in the office right now. We have policies now to go back into the facilities, but we're avoiding that as much as possible. But in terms of our investigative capacity, it is as or more robust than it was even before the pandemic. We're very, very fortunate that we have the technology that we have. We're still reaching out to witnesses. We're still conducting interviews. I spoke a little bit about our authority under the Executive Law 6312 to do examinations under oath. We've done many of them. So our investigative capacity has not diminished one bit. Obviously, we want to get back into facilities. When we have needed to get into facilities to ensure the safety of a resident, we've been coordinating with the Department of Health, and the Department of Health has been handling that for us. So we speak with the Department of Health on a regular basis, and the communication has been excellent. The coordination has been equally excellent. I know that the Department of Health is often the subject of criticism, but our working relationship with the Department of Health during the pandemic has been excellent.
Thanks, Tom. Yeah, I guess just to quickly review, clarify. So, as I said at the start early this morning, the federal rules are the baseline for everything that happens in the nursing home world. And then states can have additional rules. And as you saw from both Tom and Deb's programs, there's a lot of replication to some extent or another of the federal rules in in the state rules. They were both talking about New York, and in addition, excuse me, they can go beyond that. So what Deb was talking about in relation to 2801D of the public health law, which allows for whistleblowers, which allows for lawsuits as a way of, of trying to hold nursing homes accountable for neglect and abuse. That is an example of a state rule that goes beyond it. And then in terms of reporting, it's kind of the same situation, is that the federal rules in terms of COVID-19, in terms of COVID-19 and reporting, the federal rules changed, and then the state rules changed accordingly. And there was some overlap, but there was also some things in which it was not addressed at all by the federal law, or the federal rules, I should say, but they were addressed by the state rules. And part of that has been, just as we've seen, I think, outside of nursing homes, that there has not been a lot of coordination between the federal and the state level in response to COVID. And so that's an issue that many of you, I'm sure, have seen on the news, talked about, and it's become a political issue for a lot of people on both the Republican and Democratic side. But that there are those different issues that are coming into play here. And thank you, Tom. Thanks for those questions. The next question was what is the statute of limitations for a private lawsuit? Deb, do you know?
Sure. Yeah, glad to speak to that. And it's a sort of a tiered answer, but when we bring a claim, for example, in my firm against a facility or particular caregiver, there are several different statutes of limitation. If it's a private facility and it's a negligence cause of action, that would be a 3-year statute of limitations. If it's a medical malpractice cause of action against a private facility, it would be a 2.5-year statute of limitations. If a municipal or public facility is sued, there are different statutes of limitations. If it's a New York City facility, there are much shorter statutes. There's also a notice of claim requirement. If it's a state facility, there are also different statutes of limitations and a notice of intention to make claim requirement. If there are any intentional acts that are being sued for, there is a 1-year statute of limitations with respect to intentional acts. So it can vary quite a bit, and when those statutes begin also is really subject to a case-by-case review. So I give that as an overall answer, but it's important to look into each case on a case-by-case basis to determine the definitive statute of limitations or limitations applicable. I'll also add that if there's a death involved, the wrongful death statute in New York is a 2-year statute of limitations.
Thanks, Deb. So would there be, say someone was on and they had an issue, obviously it was within the past couple of weeks or even year or so, that would definitely be something to contact you or contact an attorney about. What about if it was 5 years ago? Like, is there any time frame beyond which they probably, it's not worth speaking to an attorney or seeking that?
It's difficult to give that overall statement. With medical malpractice causes of action, there is tolling with respect to, or it's important to assess continuous treatment and the impact that could have on the statute of limitations. So I never like saying a certain amount of time because it really is a case-by-case analysis that we do. It's always better to ask. My philosophy is it can't hurt to call and speak with a firm and have the firm say, I'm sorry, the statute of limitations has expired. It's worth the call to find out definitively and not to be uncertain about that.
Thanks. And Tom, would you say, like, if someone has a concern, like, is there a time frame beyond which they should not get in touch with Impuku, or?
No, I would agree, and Deborah's excellent answer is one of the reasons why I'm not a civil practitioner. But there are applicable statutes of limitations, obviously, for criminal actions. Felony is 5 years, misdemeanor is 2 years. But absolutely call, absolutely let us know about it, because obviously there are many different avenues that we can potentially pursue. We're also interested in hearing about historical cases of neglect or abuse. It's very important for us to know about them.
Thanks. A related question, I think, for both of you is relates to the COVID-19 immunity bill. The immunity that was passed and then rescinded it. And Deb spoke about this a lot. But does this, I guess, how does that impact if someone has a complaint or a concern coming to either one of you? Deb, do you want to go first?
I'll start. Well, as I had mentioned with statutes, each case is really looked at on a case-by-case basis. And it would really, if a resident was injured or, God forbid, died anywhere during this pandemic period of time, I think it would be important to speak with an attorney and address and discuss what happened. And the attorney can then look at those facts based upon the law and determine if something can be done. I would never just universally say, based on whatever legislation we had or now have, that someone should feel that they don't have a case. It would definitely be important to speak with someone and have that case evaluated on the facts specifically.
Thanks, Deb. Tom?
Yeah, my answer would be the same. In terms of Mafuku's investigations, we're continuing to investigate. Obviously, the immunity statute does have limitations. It doesn't cover intentional acts, doesn't cover gross negligence, it doesn't cover reckless misconduct. So from a criminal perspective, it's close to business as usual. The immunity statute would not affect those types of investigations. And Deborah's analysis is right on in terms of we're far more interested in identifying those situations than assessing, doing the legal analysis, rather than just assuming that the immunity statute would cover a situation, because there's far more that we could do, and that includes just learning from this experience that we're all going through, and identifying best practices and bad practices. And that's something that we're hoping to do as well.
Thank you. So this question is, are you looking into putting cameras into residents' rooms to directly follow the care of the residents and for families to feel more comfortable in knowing and being able to see the care their loved one is receiving? Tom, do you want to?
Yeah. Medicaid Fraud Control Unit has historically used cameras as an investigative technique to uncover and document neglect and abuse. It's something that we're certainly planning on doing. There are certain requirements. The privacy of roommates, for example, needs to be kept in mind, but every individual in New York has the right to install a surveillance camera. Their families have that right, and it is something that we use when appropriate as an investigative technique. We've certainly had many successful cases where we have used camera footage as evidence in those prosecutions.
Thanks.
There are a lot of states across the country that prohibit the use of cameras, which is very, very unfortunate.
Interesting.
Yeah.
I wasn't aware of that. I know that there's been some bills in states to allow it, which to me seem redundant because it's a person's home. But that's I didn't know about. I'm going to look at that too. That's very interesting.
That's right. Yeah, and it goes back to that premise that it's the person's home. They also have very stringent requirements when using cameras, including putting a big sign on the door saying that there's a camera in use, which often makes the use of the camera completely useless. Although I guess it does have some positive effect, if they behave properly, knowing that there's a camera there. But in terms of uncovering neglect and abuse, and really identifying either the culture within the facility, which is something that we're always interested in, or the bad actors. You have limitations if you can't have the covert type of camera surveillance.
And if I could just add, if you don't mind, Tom, I know that there have been cases over the years from the Mfuku that they use the facility's own cameras, because facilities quite often now have cameras in hallways and other public areas. So I know it was actually on TV a lot here several years ago. There was someone who was abused right by a nurse's station where there was filming of it, and they actually showed that film on the news. But that there was also cases of even neglect, I think, neglect cases where they could see that from the camera in the hallway that no one had gone into a room for, like, I think it was 8 hours, and they had documented that they were providing care during that time when they obviously hadn't been.
Yeah, I mean, there are a lot, and Deborah can speak to this as well. There are a lot of key pieces of evidence that we look for when we start investigating a case, and certainly the facilities surveillance footage from public areas is something that we're always interested in obtaining and reviewing. It often says a lot. It works in both ways, though. Sometimes it shows neglect and abuse. Sometimes, though, we've used it to vindicate caregivers that have been falsely accused. So it's very important. We'd like to see all facilities use it. Not all do, but it obviously is a very relevant piece of evidence when we can obtain it. We were talking about timing. Timing is so critical in many of these investigations for a lot of reasons. But in ensuring that we find out, the Medicaid Fraud Control Unit and other government agencies find out about these incidents as quickly as possible is important, because a lot of the camera footage does get overwritten, and we want to get in there as quickly as possible and secure that evidence.
Thanks. Deb, I was wondering, I know that you mentioned the case before with the woman and her grandmother, but in terms of just if you have any thoughts for people as they're considering this.
Well, I feel if people are concerned and they do suspect that neglect and abuse is occurring, that they do that. And as Tom mentioned, there are privacy concerns that it should be focused just on the resident and not the roommate. Tom, I wanted to ask you, my understanding was that the video should not record audio. It should just be recording video, but that's long been my thought, but I want to confirm that that's your feeling as well with that.
Yeah, we frequently do not include audio, and we make that investigative decision because, especially if it's a roommate environment, the rights of the roommate are implicated. We might not be able to get consents from the roommate. And obviously, private information, HIPAA type of information could get captured on the video that ultimately may preclude us from using it as evidence down the line.
Okay, thank you.
Yeah.
Thanks.
We also do use the facility video. We request that in cases where we feel it is appropriate, and we certainly have had specifically fall cases where someone has fallen either at the nurse's station or in the hallway, and the video has depicted that fall. I think of one case comes to mind right away when I think about that, where a gentleman was left alone in the hallway, and he had a private aide who was with him, and the private aide went to the nurse's station, said, "I'm going to go and get a cup of coffee. Please know that Mr. X is here." And the video showed that no one came to check on him. Amount of time elapsed. He got up. It took him a while to get up. He walked several steps before he even fell, and no one was attending to him. And unfortunately, he fell and sustained fractures. And I also wanted to add, when we're contacted in a case where we think a video may be depict evidence with respect to the incident, we'll send something, what we call a spoliation letter, to the facility to put them on notice to preserve that video, not to destroy that video, because it will potentially be evidence in a case. So just a suggestion, if something happens to someone, the sooner one acts to try to preserve evidence is important, because as Tom mentioned, sometimes that video isn't preserved, or sometimes facilities record over it after a certain period of time.
Thanks, Deb. The next question is for Claudette, and I would say Tom as well. And the question is, can reporting be anonymous? Claudette, do you want-
For our
yeah.
program, yes, reporting can be anonymous, and we would investigate it that way as an anonymous complaint. If it got to the point that we'd have to further the investigation with needing more information to identify the person, we would talk with that complainant and determine if they want us to continue or if they'd like us to stop investigating at that point.
And what if it, the person also asked, same person who asked that question asked, what about protecting the staff member reporting, which I think I want to ask Tom as well. But for you, I mean, I guess I hadn't thought about it. So, but in terms of the ombudsman, you know, you could obviously get complaints from staff because you can get anonymous complaints. But how would you, I guess if you have any thoughts about that, you know, coming from a staff member?
We do get complaints from staff, and we do try to assist them with navigating the issue without identifying them. And sometimes we can do that through interviewing other residents or talking with other staff, gaining more information, looking at records if we have a specific resident that is willing to let us look at those records. So we do try to navigate that process without identifying a staff.
Thanks. Tom?
Yeah, we certainly do. We welcome all complaints. We would prefer, obviously, that someone identify themselves, but we routinely get anonymous complaints that are very, very helpful in starting investigations and addressing often very serious issues. So we absolutely can do that. We make great efforts to protect the identity of witnesses going forward, but just learning about an incident is incredibly important. So I'd encourage everyone to do that. If they're not comfortable giving us their identifying information, we'll happily accept anonymous complaints.
Thanks. Thank you. So there's actually two questions related to staffing. The first one is, do you encounter barriers to interventions when the definition of elder abuse and adequate staffing has no universal definition and can be very subjective? What are your recommendations for dealing with these potential barriers if one encounters it? And the second question is, are facilities required to post daily staffing ratios, and how would one know what is considered understaffing? Would any of you like to take a shot at those? Well, I can. So, you know, in what I talked about before, in terms of our program, and you know, in terms of the federal rules, which are of course the state rules as well, you know, we have some definitions, some very good definitions of elder abuse. We have very good definitions, as Deb mentions a lot in her program, about standards of care, and that's what's required here. And I think Tom had said also that, you know, that could be a defense, an appropriate defense of facilities, that we follow the standard of care. I think it was Tom said, it might have been Deb, I apologize. And this happened anyway. So the point being is that for every, you know, pretty much anything that affects a resident, whether it be nutritional status or certainly falls prevention, pressure ulcer prevention, and pressure ulcer treatment, there are standards of care that are out there. We're not expecting nursing homes to perform miracles, but we are expecting them to meet the professional standards of care. And as I said earlier in the morning, those are the requirements that they agree to be meeting when they take in a resident. They have to be doing a resident assessment, and they have to be developing and implementing a care plan based upon those needs of the resident that have been identified. So, you know, so we do have some good definitions. And as I also said, in regard to the staffing, is that over and over again in the rules, and this is one change that we did see in 2016 when those, as I said, the rules originally came out in 1991, they were revised in 2016. There's a lot of that revision is looking to see, are the staffing there? And if the staffing is not, is not there, that they're identifying that as surveyors. So there are a lot of good questions. We've done some work in the past, some webinars on the survey, and we have those on our website. We'd be happy to do it again if people are interested. But there is, it's not a storage unit that nursing homes are running. This is not a factory that they're producing equipment. Everything, as Tom and Deb said, has to be resident centered. And that includes having enough appropriate staff with the competencies, with the training, et cetera, to meet residents' needs. And then I would just lastly say that facilities do have to post their staffing in the facility for each shift. They do not have to report staffing ratios. Essentially, I would say it's a very rough number, but one that has been shown over the years to be appropriate. Residents, a typical nursing home resident needs about 4.1 hours of direct care staff per day. That's a resident, based upon typical resident needs. It comes from a 2001 federal study. There's, more we could talk about that. I don't want to take up our time. We're close to the end, but that's it roughly. A facility should be providing about 4.1 hours of direct care staff, with about 0.75 or more being provided by an RN. Another question, we may only have enough time for one or two more. So one I wanted to ask, this is for Tom. Does your office investigate corporate ownership groups that hide their profits, their nursing home profits, in having several companies, such as land ownership, facility ownership, supplies, pharmacy, et cetera?
The short answer is yes, and that's where our auditors come in. As I mentioned, a real concern of ours is that Medicaid funds are used for patient care. And we do, in a typical institutional nursing home investigation where there is evidence of grossly substandard care as a culture, we will follow the money. And our auditors are experts at tracing money. We are very familiar with corporate structures. We're very familiar with money laundering techniques. We're very familiar with inappropriate management schemes. We do look at them. That was something that we've uncovered in several historical investigations, including the Medford investigation, where we did see a layered corporate structure that really was designed to pull money out of the facility. And that was addressed by ensuring that there was a patient care fund that was dedicated to ensuring that there were sufficient funds to adequately care for the residents in the facility. So, on the fraud side of the house too, we're also very experienced in chasing down white-collar criminals who use complicated financial transactions to try to conceal criminal proceeds. So, kind of one of the areas of our expertise.
Interesting, thanks. And this is a major issue for us in our advocacy as well as an organization. I have one last question, and I think maybe it's possible all three of you could have an answer for that. I'm going to start with Claudette, though, because I think I'd be interested to hear how the ombudsman would handle this. Is there any recourse for residents whose physical and/or occupational therapy has been withdrawn because of reaching a quote-unquote plateau?
We get a lot of those complaints related to therapy ending, and the program does speak with the facility about, when was the last therapy evaluation, trying to work through those issues with that's a very gray area, because residents have the right to maintain their highest level of functioning. And a lot of facilities do try to cut their insurance from, if they're there for rehab, before maybe a resident feels that they've met their best level. So we do work, it's kind of individually based, but we do work with facilities to try to assist with that. I mean, if they've hit their 100 days under Medicare, it's a little bit different, but they still should be receiving some type of therapy or, continued walking program or such to maintain their highest level of functioning. That's the goal that they should be meeting in every facility for every resident.
Thanks. Tom, is this an issue that you all have dealt with? And if so?
No, I've dealt with it personally, but as far as the work that we do, familiar with the issue, but it really hasn't come up in terms of our investigation.
Thanks. And Deb, I don't know if this is something that someone would come to you about, or if it would have a role in any of the cases that you've seen where someone, maybe has deteriorated and maybe even worse things happen to them because they didn't get the therapy services they needed.
We often also do hear a lot of complaints about that from families, that they feel that someone's therapy has been terminated prematurely. And I would echo what Claudette said, that it's not necessarily, therapy is not required necessarily to improve someone's levels, but it is required to maintain, and maintaining is critically important, because once someone's levels start deteriorating, that subjects them to a whole host of other problems that can result in falls and ulcers and things as their mobility declines. So I would encourage families to push for therapy to maintain. That's critically important.
Thanks so much. Well, thank you again, Deb, Claudette, and Tom, for being on the panel. Thank you, everyone who joined us today. I'm sorry that we didn't get together in person, but it was nice. We were able to have a lot more people than we normally could in person as well. We're going to post the program on our YouTube page. We have the resources that we will be posting on the page for this program, as well as elsewhere on our website. I thank you all again. Oh, I should also say, just in response to that last question, a shout out to another organization with which we work closely, is the Center for Medicare Advocacy. Has actually done a lot of work on the so-called improvement standard for access to physical and occupational therapy. And just to be clear, there is no improvement standard, as their lawsuit against, I believe it was CMS, found you don't have to improve. Plateauing is not a issue as well, as long as you need the therapy services. This is under Medicare, just to be very clear. But as long as you need those therapy services, as long as you need those therapy services in order to maintain your physical or other ability, you have a right to receive those services. And as Claudette said, for anyone, no matter who pays for your care, you have the right, as we started off this program by saying, to have the care and the services you need to attain and maintain your highest practicable well-being. So thanks so much. We will review, at least internally, the questions here and try to do some responses. As you all know, we're a small group, but we'll do what we can. But thank you all for attending. Thank you again to our panel, and have a nice afternoon.
Thanks, everyone. Be safe.
Thanks. Bye-bye.